May I please, Your Lordship?
Yes, please.
May we please to mention item number 6, Your Lordship?
Yes,
Your Lordship, let the matter come up after 3 weeks. I need to receive instruction, Your Lordship,
you're for,
for the state respondents, Your Lordship.
and who is for the petition?
For the petition, please.
Okay. Planet, you are
State, for the state respondent, Livika.
government,
Livika, yes,
Okay.
government.
Miss Livika. Government, okay. Huh? Some is that this matter may come up after 3
3
weeks,
weeks, Your Lordship.
as he has to obtain instruction.
Yes, Your Lordship.
Stop. The Learning Council for the petitioner, Miss, is also present and has no objection. Stop. List this matter after 3 weeks. Okay.
Much obliged.
May I please, Your Lordship? My lord, I beg to mention item number 23, hearing item.
23.
Your Lordship, here by the order dated 8 May 2023, a black court has directed the learned lower court to take additional evidence. So additional evidence is not completed. I'm for the state respondent.
Okay. Okay. And who is for the petitioner? Petitioner not present.
I think he is all the way from the Gauhati.
Okay.
So we have discussed. Then I'm praying for 4 weeks time to
Okay.
complete the additional evidence.
Mr. Santosh, you are
Additional AG
additional AG
in teams.
submits that in the instant case, the state had to file, or it was directed to?
Additional evidence, put the parties. That is as per the direction of the Honorable Court.
Okay, as per the direction of
Yes,
Honorable
to
Court.
take more additional evidence in the learned lower court.
Okay,
So that additional evidence is not completed.
okay.
It makes
Submits that as
some
per
more
the direction of this court, additional evidence was to be, evidence or affidavit?
additional evidence has to be recorded
Additional evidence was
of
to
the
be.
parties.
The trial court was directed to record additional evidence by both the parties. But however, the same has not yet been done,
Not completed.
no, not yet completed, and prays for 4 week time.
4 weeks time.
Okay. The prayer is allowed. List the matter after 4 weeks.
4 weeks.
Okay.
Your Lordship, here I pick to mention item number 7 to 11 is a review. Here I'm the applicant. So the Lordship, this matter may be listed on 16 Thursday,
16. Okay. Before this court. So 16 would be a little difficult. After 16,
Tuesday. How about next Tuesday?
next Tuesday.
Yes.
Okay. You are for the
I'm for the
revision petitioner.
Respondent, Your Lordship.
You are for the respondent. Who
Yes.
filed this revision petition? State.
We have
State.
state is
Okay,
applicant.
Mr. Additional Advocate General, prays for listing this matter next week.
Next week.
Okay. To which the Learning Council for the respondent has
Lordship,
no
that is-
objection.
The minimum effects on 21st, Your Lordship.
21st.
21st.
Yeah, next week.
Pray for fixing the matter on 21st, to which the Learning Council for the respondent, you are for respondent.
Yes.
There's no objection, stop. List this matter on 21st.
Obliged.
Quiet, Mr. Huh?
Please, Lordship, Lordship, better to mention item number 2 and 3. Lordship,
Yes.
Here the matter is now before the cabinet for its approval. So Lordship, I pray that 4 weeks time may be granted.
This is for?
This is for ward charge regularization.
Okay, okay.
Yes, so the matter is before the cabinet for its approval. And once the cabinet approves, then the regularization order will be out.
Your Lordship,
Yeah.
since this is contempt petition and this was filed in the year 2020. So if your Lordship can kindly direct the respondents to take appropriate steps at the earliest.
Lordship, the matter is before the cabinet and it is beyond our control to direct the cabinet to take up. Lordship, though we are pursuing the matter earnestly, Lordship.
Learned, so Miss. So Learned, you're for the respondent. were?
Respondent number 2 to 5, Your Lordship.
Okay, respondent number 2 to 5.
Yes.
Submits that the matter for consideration of the case is pending before the cabinet,
Yes, Your Lordship.
which is beyond the,
Control of the respondent's
which
lordship.
is beyond the control of the respondent authority. And pray for how much time?
4 weeks, Your Lordship.
Further 4 weeks time. Stop. The Miss
Berta Tep,
Learning Counsel for the petitioner is also present and submits that since the matter is of 2020, the same, the respondent authority may direct it to expedite the matter. Stop. In view of the above, this matter after 4 weeks, however, the learned respondent shall make an endeavor to expedite the matter as early as possible. Okay.
Much obliged.
Pursue
Lordship,
the government to expedite the matter. Okay,
Lordship, item number 12.
item,
Number 12. Lordship, here the stake we have already filed an SLP before the Supreme Court. So Lordship, I pray the 4 weeks time may be granted to list the matter after 4 weeks, Your Lordship.
yes. Who has filed SLP? State.
Yes, yes.
Miss government advocate,
Lordship,
you are,
as an additional AG, Your Lordship.
sorry,
For
Learned Additional Advocate General,
respondent number 2 to 6, Your Lordship.
who, representing respondent number 2 to
To
6,
Yes.
submits that the state has filed SLP before the Honorable Supreme Court
Yes, Your Lordship.
and prays for
4 weeks time, Your Lordship.
4 weeks time. Stop. Learned Counsel for the petitioner, Mr. is also present. In view of the above, list this matter after 4 weeks.
Lordship,
weeks.
I have similar prayer in item number 16.
Okay,
Yes. For all the respondent here. I have the similar prayer, Lordship.
you have no objection.
Yes, Your Lordship.
You are praying for?
Praying for listing the matter after 4 weeks as the stake has already filed an SLP before the Honorable Supreme
Here
Court.
also?
Yes, Your Lordship.
Okay. Miss Learned Additional Advocate General, Nagaland, submits that in the instant case, the state has filed SLP before the Honorable Supreme Court and prays for listing the matter after
4 weeks. Your
4
Lordship.
weeks.
Yes.
The Learned Counsel for the petitioner, Mr. Walling, is also present. In view of the above, list the matter after 4 weeks.
Much.
Okay. Yes,
May I please, Your Lordship?
yes,
Lordship, I beg to mention hearing item 27.
I think 27.
Lordship, I pray, may your Lordship be gracious if this matter may come up after 2 weeks.
You are for?
The appellant, Lordship.
Okay. Mr.
V. Koza.
Koza, Learned Counsel for the appellant. Prays for after
2 weeks.
listing the matter after 2 weeks. To which the Learned Additional Advocate General,
Lordship,
government,
I'm the PP.
who
here.
represents him?
PP here.
Or PP here?
Yes, yes.
Okay, PP. There's no objection. Stop. List the matter after 2 weeks. Okay.
Deeply obliged.
Please, the Lordship. Lordship, I beg to mention item number 15, Lordship. 15.
Yes.
Lordship, I pray that this matter come after 3 weeks, Lordship.
Okay, who is for the appellant? Okay,
Lordship, I'm for respondent number 2, Lordship.
okay, Lanet,
Uh,
No
Your-
objection, your lordship. I'm for the petition.
okay. Your PP here, Lanet. Oh, so Mr. Sons, Lanet PP. Praise for 2 weeks, 3 weeks, okay. Praise that the matter may be listed after 3 weeks, to which the land council for the appellant has no objection. List this matter after 3 weeks. Okay,
Lordship, may I please, Lordship? Lordship, I'd like to mention item number 4 and 5, Lordship.
item
4 and 5, Lordship,
4 and 5.
for respondent number 4 and 5. Lordship, kindly list this matter after a week.
You are for?
Lordship, respondent number 4 and 5.
In item 4 and 5.
Yes, Lordship.
You are praying for what reason?
Lordship, here, my senior is in this post.
Okay,
No objection.
okay. Learned advocate, Mr.
Mr. Kachish, Lordship.
appearing on behalf of his senior, Mr. Senior name
And Lungkumar, Lordship.
and Lokumar, and counsel for the respondent, praise for adjournment of the case for
1 week, Lordship.
1 week, as his senior is under indisposed, stop, and counsel for the petition, petitioner, Mr.
So
is present, and he has no objection to the prayer made by the learned counsel for the respondent, stop. In view of the above, the case is adjourned, list the matter after,
For a week, Lordship.
after a week.
Yes, Lordship.
Okay.
Yes, Lordship.
Lordship, I beg to mention item number 14, Lordship. Item letter, Lordship.
Item 14,
Lordship. Lordship, I'm appearing on behalf of my colleague, K. Angami, Lordship. If this matter can come up after 4 weeks, Lordship.
okay, you are a respondent,
Lordship, for the respondent.
yeah, no, okay. Learned advocate, Mr. Okay. This is content, na? Appearing on behalf of Mr. K.
K. Angami.
Okay, Angami. Learned counsel for the respondent number. He is for respondent number or respondent authority,
For respondent.
for respondent authority, for respondent.
No.
Praise for adjournment of the case for 4 weeks, to which the learned counsel for the petitioner, Miss, has no objection, start. List the matter after 4 weeks. Okay. Is prayed for, list the matter after 4 weeks, okay.
May I please, Lordship?
Yes.
Lordship, I beg to mention item number 21. Kindly the matter may be listed after 3 weeks, since the written service report is still awaited.
You are for?
I'm for the petitioner, Your Lordship.
Okay. You are praying for 3 weeks.
3 weeks' time.
Land counsel for the revision petitioner, Miss, prays for listing the matter after 2 weeks. Stop. Prayer allowed, list the matter after 3 weeks. Okay,
Much obliged.
Yeah, please, Lordship.
yes,
I beg to mention item number 13, Your Lordship, 1-3. On behalf of the council for the leading petitioner, Lordship, PP Paul. So since he has some personal difficulties to this, so I pray that this matter may come up on Monday, Your Lordship.
you are mentioning on behalf of,
PP Paul, Lordship, council for the petitioner.
okay. Learned advocate,
Your Lordship, for reason number 3, Your Lordship.
okay. Learned advocate,
Yes, sir.
you are
Made of Your Lordship, on behalf of PP Paul,
appearing on behalf of
PP Paul.
PP Forte,
Paul, PP Paul,
learned counsel for the petitioner.
petitioner.
Submits that why you are
He's in this post, Lordship, so I pray that this matter may come up
That,
next week, Monday.
that Mr. Pote is indisposed.
Yes,
Okay. Indisposed and prays for, and prays that the matter may come up after.
next week, Your Lordship, Monday.
Okay, the matter may come up on the next week. Stop. Learned counsel for the respondent number
3, Your Lordship.
3 is present. And he has no objection to the prayer made by the learned counsel appearing on behalf of the learned counsel for the petitioner. Stop. Prayer allowed. List the matter. No.
Date 20, Your Lordship. This month,
Okay, list the matter on 20.
20, Your Lordship.
Okay. For this has come up on admission. Okay. Okay, that's fine.
Your Lordship, there's an interim, Your Lordship.
In the meantime, the interim order passed earlier shall continue.
Apply to. Your Lordship, I have a similar prayer for item number 33, Your Lordship.
Item 33.
On behalf of counsel for the petitioner, PP Paul, Your Lordship.
Okay,
Similar prayer, Your Lordship.
similar.
Listed
prayer.
matter on 20.
You are for respondent.
For all the respondents.
For all the respondents.
Yes,
Okay, similar order, write his name. Okay. Okay. After 3 weeks.
No, date 20, Your Lordship.
28.
Yes,
Okay.
apply to.
May I please, Your Lordship?
Yes,
Your Lordship, I beg to mention item number 17, Your Lordship.
17.
Yes, Your Lordship. Your Lordship, here the respondent number 2 have filed the affidavit, Your Lordship. If 2 weeks time be given, Your Lordship, to file or reply, Your Lordship.
Yes, okay. Learned advocate. Your good name?
I'm Solo, Your Lordship.
Samich, that you have received a copy?
Yes,
Okay.
Your Lordship.
Uh,
Filed by respondent number 2.
Okay. A praise for how much
2
time?
weeks time, Your Lordship.
2 weeks time to file reply affidavit to the affidavit filed by the respondent. Stop, huh? Learned advocate. Mr. Miss, you're for,
Respondent number 2.
and you're for?
For the state, Lord.
Hmm?
For the state.
State,
One is
okay.
one.
Okay, respondent number, Mr. So-and-so for respondent number 1 and Miss so-and-so for respondent number 2 are also present. Stop, huh? And they have no objection to the prayer made by the learned counsel for the appearing on behalf of the learned counsel for the petitioner. Stop. Prayer allowed. List the matter after
2 weeks, Your Lordship.
2 weeks.
Your Lordship, I also beg to mention item number 32, Your Lordship.
Item 32.
Your Lordship. Your Lordship, I pray that the matter be listed after 1 week, Your Lordship.
You are for,
The responding, Your Lordship.
and who is for the petitioner?
I'm for the petitioner, Your Lordship.
Learned counsel for the petitioner. I've also heard Mr. Petitioner name, huh?
Philip Lorin.
Okay. I've also heard Mr. Learned counsel for the respondent number.
Respond 1, Your Lordship. So responding, Your Lordship.
Okay. Learned counsel for the sole respondent and praise that the matter may be listed after
3 weeks, Your Lordship.
3 weeks.
Your Lordship, next week, Your Lordship. If a date be fixed, Your Lordship. Date 21, Your Lordship.
6. Okay. Praise for fixing the matter on
21, Your Lordship.
21, to which the learned counsel for
No objection, Your Lordship.
the petitioner has no objection. Stop. Huh? List the matter on 21st. The prayer is accordingly allowed. List the matter on 21. This is for hearing. Okay, for hearing. Okay.
Please, your lordship. I
Yes,
beg to mention item number 26, lordship.
26.
Lordship, let it come up on the 20 November, next Monday.
20.
Yes, sir.
Learned counsel for the petitioner, Mr.
Sidirung Singh.
Praise that this matter may be listed on 20th. To which the learned counsel for the respondent number,
Number 3.
Miss so-and-so, and state also, and Miss so-and-so appearing on behalf of the state has no objection. Stop. List the matter on 20, okay, for hearing. Okay.
For motion, item number 1.
May it please lordship.
Yes.
My lord, I'm aggrieved by the impugned order, which is at page 44, Annex 10, my lord. Annex 10, page 44, my lord.
Page 44.
Page 44.
You are agreed by this page 44.
It's page 44, Annex 10, the impugned order.
Page 40. 44 is, what is this?
This is the impugned order passed by the civil judges in the division Dimapur.
Are you in the same petition? 44 is something else. It's a petition. This is a petition, copy of the petition.
Yes, my lord.
Oh, this is a copy of the petition. Are we in the same page? 44?
Yes, 44, page 44.
Yes. Kindly read page 44.
Page 44 is the order passed by the,
No, this is not an order. Can you check?
the relevant part starts from page 47, my lord.
47.
Yeah, 47, order, the relevant part.
Okay.
Yes. Page 47,
Just a
relevant
minute,
part,
just-
yes.
I thought this is something. Okay, order 47. Please read.
Yes, my lord, in this case, the principal plaintiff in the civil suit has expired on 2020 January. And then I filed for this case wherein the wife had filed for a substitute. And then my petition was rejected only on the ground of that I was barred by limitation, my lord. But then this case discovered the spirit has been excluded from limitation by the Honorable Apex Court.
Have you filed condemnation petition?
Yes, my lord, I have filed, but then that has been rejected on the ground that I am delayed by 700 something days. My lord, what happened in this case is that I have filed a civil suit in 2019. In 2020, January 30, the principal plaintiff expired. And then I am represented by the power of attorney holder. In the year 2021, a new power of attorney has been executed. And then I have filed a petition for substituting, impleading the wife,
While the suit was still pending.
still pending.
Okay,
It is still pending as of date,
okay.
my lord.
So in the meantime, the petitioner died
Petitioner died.
and then you filed.
I filed
So
a
you-
substitute petition, impleading the wife. The wife has come as a plaintiff, and still the present petitioner is the power of attorney holder. And then the new power of attorney has been executed in my favor, and then I have filed a new petition. But then my petition for substitution has been rejected on the ground that I am barred by limitation. But as per the Honorable Apex Court,
What is the time, what is the limitation for filing substitution?
90
petition?
days.
90 days.
Yes.
Okay. There was a delay of how much?
I am within limitation, my lord.
Within
The only thing
limitation.
is that the trial court below did not take into consideration the excluded period of limitation passed by the Honorable Apex Court, which can be found at page 59, Annex 13, my lord. The Honorable Apex Court order. I have annexed the same. Relevant part is at page 61, my lord. Para 5.1.
Relevant.
Page 61, para 5.1.
Okay,
May I read, my lord?
yes, please.
Para 5.1. The order dated 23/3/2020 is restored, and in continuation of the subsequent orders dated 8/3/2021, 27/4/2021, and 23/9/2021, it is directed that the period from 15/3/2020 till 28/2/2022 shall stand excluded for the purpose of limitation as may be prescribed under any general or special laws in respect of all judicial or quasi-judicial proceedings, my lord.
So your period cover under this,
Yes, my lord.
okay.
And then the trial court below did not take into consideration this aspect, and only on this ground, my petition for substitution of the legal head has been rejected, my lord. This is the only issue in this case.
So this was placed before the trial court also,
Yes,
this
my
order
lord.
was. So what the trial court says about this order? Whether, has he considered this order also?
Yes, I have presented the same before the trial court, but then that has not been taken into consideration, my lord.
Okay, not taken into consideration. Okay. So issue notice?
My lord.
Hmm. The state, huh? The petitioner by this application under section 115. So 115 of Civil Procedure Code 1908, read with Article 227 of the Constitution of India. Challenges the order dated. What is the order?
4/8/2023.
4/8/2023, passed by the civil judge. Passed by the civil judge, senior division, Dimapur, Nagaland. So on the ground that, what is your ground?
Grounded, I am barred by limitation.
On the ground that no, you are barred by, no. What was the ground taken by the civil judge?
That can be found at page 49, my lord. The specific.
Yes, where? 49. That although what was it, where is the Supreme Court order?
Annexure 13, page 59. my lord.
Although the limitation, although the Honorable Supreme Court in 2022 3 SSC 117 has directed for exclusion of the period of limitation from 15/3/2020 till 28/2/2022. But the Lana Civil Judge, Senior Division, has not considered and taken into, not taken into consideration of the said order and rejected the prayer for the condonation of delay for in filing.
For filing the substitute petition,
Mm.
impleading the legal heirs of the
Substitute
plaintiff.
petition impleading the legal aid,
Of the
sorry,
plaintiff.
legal heir
Yes.
of the petitioner. Stop. There are done counsel for the petitioner, Mr. So issue notice returnable by, where is returnable by 3 weeks.
3 weeks.
Okay, stop. The petitioner shall take steps upon the respondent within 3 days.
3 days.
Stop. 3 days by a registered post with a record. Stop. List is matter after 3 weeks.
Applies, madam.
For motion, item number 34.
Yes.
May I please, Your Lordship? Your Lordship, this is an application, bail application under section 439 of CRPC, praying for release of accused person on bail, Your Lordship.
What is the offense involved? Offense, it's NDPS case.
Yes, Your Lordship.
Okay. Let us see the FIR. What is?
Your Lordship, the FIR is, Your Lordship may kindly turn to page number 28. Lordship, may I read out the brief
Please,
act of the case?
Please.
Your Lordship, this instant case happened on 19th of August 2023. The Kusama police personnel, they intercepted.
19 August.
Yes, Your Lordship, 19th of August 2023.
The FIR is in
FIR was lodged on 20 August
it's
2023.
July. It's July.
Oh, yes, Your Lordship, it's July.
Yes.
The Kusama police personnel, they intercepted a dumper truck at the Kusama check gate. And on checking, they recovered 30 nodes of suspected heroin. And in this connection, they arrested the driver named Subhash Bista.
Okay.
And a so moto FIR was lodged against the drivers Subhash Bista. And the matter was endorsed to the investigation officer for further investigation. Your Lordship, that on prior information given by the driver accused Subhash Bista, the IO had arrested, in this connection, the IO had arrested 2 other accused persons, namely Abdul Ahmed. He was arrested from New Lem, Dimapur. And another accused, the present accused, whom I'm representing, accused Amusana Singh. He was arrested from his home at Madhapur village in the state of Assam. Your Lordship, my grounds for the bail application is that, firstly, the arrest of the accused was not an arrest based on chance, Your Lordship. The arrest was made on the basis of prior information given to the IO, where the provisions of Section 42 of the NDPS Act is mandatory. However, Your Lordship, the IO, on receiving the information and on taking the information from the earlier accused who was arrested in connection to this case, he had not complied with the provision that is given under Section 42 of the NDPS Act. Lordship, Section 42 of the NDPS Act, when it comes to prior information, it is a very stringent provision which should be complied. Lordship, secondly, accused Ambusana, he was arrested at his home at Madhapur. village in the state of Assam, which is in the
You are
jurisdiction of
filing
another
this
state.
filing this application on behalf of how many accused?
Your Lordship, there are 3 accused persons.
So this application is for 3 accused person.
No, one for one accused person,
Only for one
accused
accused
Ambusana
person.
Singh.
Okay.
Your Lordship, he was arrested in the jurisdiction of another state. That is before sunrise at around 4 a.m., Your Lordship. And as far as interstate arrest is concerned, Your Lordship, the IO did not seek to follow any procedures under the CRPC.
Have you
And-
made an application before the trial court?
Yes,
you-
Your Lordship. Yes, Your Lordship.
You moved bail application before the trial court?
Yes, Your
So,
Lordship. And the
Okay.
bail application was rejected.
rejected.
Yes, Your Lordship.
What was the ground taken there?
Your Lordship, have filed the bail application on the grounds that there is gross violation of Section 42 of the NDPS Act and even the CRPC with regard to interstate arrest, since the investigation agency has not complied with any provision
Okay.
with regard to interstate arrest, Your Lordship.
Whether the trial court has considered?
No, Your Lordship. Your Lordship, my prayer was not appreciated on the grounds that the enough time opportunity has been given to the investigation agency for investigation.
So that was appreciated. What is the new ground you have taken before this court?
Your Lordship, I'm coming here on the grounds of procedural lapses, Your Lordship.
But that was considered by the trial court also, special judge. There was no lapse. Have you annexed the rejection order?
Your
Have you
Lordship,
annexed-
I've reflected in the cost title, but I have not annexed the order here, Your Lordship.
Should have annexed. Your ground taken by you must have been also appreciated by the learned trial court while rejecting your bail. You should have annexed that order also. You produced that order also, okay, but in the meantime, we'll issue notice.
Okay, Your Lordship.
You should have.
I apologize, Your Lordship. I've overlooked that, Your Lordship.
Okay. Yes, state.
As Lordship has rightly pointed out, Lordship, this, the rejection of bail order is not here, Lordship.
Yes,
So,
that should
Lordship,
have
that has-
annexed.
They should have annexed that order, Lordship.
Yes. What is your prayer, by the way? This is, seems not, okay, 39 also. Okay. Third, learned counsel for the petitioner, Miss. You are
Cricket.
Crete. Crete. And also Mr.
Digimon.
Tana PP, huh?
No.
Staff, huh? Para, this is an application under section 439 of the Code of Criminal Procedure 1973. 1973, read with section 37 of the NDPS Act, praying for release of accused. What is the name of the accused? Ambusana Singh, who has been arrested in connection with the, where is the case number? Special case
40 of
number
23.
40 of 2023, arising out of case number 1623, Kozama PS under section 21C/60 of NDPS Act. Stop. Issue notice. Stop. Call for. The case is pending before.
Sessions Court, District and Sessions Court, Your Lordship.
No, when he was arrested, you said,
Your Lordship, the present accused was arrested on 20 of July
July, whether
2023.
charge sheet filed now?
Charge sheet is yet to be filed, Your Lordship.
Not yet filed.
Yes, Your
So
Lordship.
it is still before the police only?
Yes, Your Lordship.
No, then it is not a special case. So why you have mentioned this special case number so and so also? The case is still before the police only. Charge is not yet filed before the special court.
Yes, Your Lordship.
So this is special case number is a bail, must be bail application filed by you. Charge is not yet filed, no cognizance has yet been taken by the special court, so it should not have. This must be your bail application only, special case number so and so. Special case number 40 is your bail application number only, it
Yes, Your
appears.
Lordship. Special case 40 of 23.
Lordship, to make the things very clear, Lordship, Lordship, may kindly come to page 2. Page two of the petition. Here,
Page
page 2.
two,
Page 2 of the petition, bail petition.
yes,
Yes, here on top, it says that impugn order that is 3/10/23 passed by the learned special judge NDPS Kohima in IA criminal bail application number 204/2023. Here it's mentioned about the special judge, that the bail that was moved before the,
it's a bail application only.
yes, Lord.
Yes.
So now that change it, issue notice. After that, call for the case diary.
Lord,
Scan copy of the case diary.
scan.
Scan copy. Call for case diary. The Lana PP shall produce the scan copy of the case diary of Khajama PS. No. Khajama PS case number is 16.
Case number 16 of 23.
As a
Yes,
case number 16/23. Khajama PS under section 21C/60 of NDPS Act. Stop, List this matter. After, how much time it will take?
After 2 weeks, Lord.
After 2 weeks.
2 weeks.
Okay.
In the meantime, let the council also place the impugn order. That was.
You also, next time you place the impugn order also, obtain a CTC of the impugn order and place it.
all right, Your Lordship.
Okay.
Oblige, Your Lordship.
For admission, item number 18.
May I please, Your Lordship?
Yes, please.
Your Lordship, kindly list this matter on Thursday, Your Lordship. LCR has been called, so, Your Lordship, the President Council may kindly be allowed to peruse the LCR, Your Lordship.
LCR, have we received the LCR?
Yes, ma'am.
Okay. Next week, Thursday probably would
This
be,
week, Thursday, Your Lordship.
Thursday would be
for-
difficult.
Either Thursday or
Next,
Friday. Your
next
Lordship.
week, Lord.
Next week, Thursday will be difficult because in the first half only, after 11, this court will leave. So, next week, Monday, Tuesday.
Next.
Okay,
Then, Your Lordship, it may be fixed on Monday.
okay, it's prayed for by the Land Council you're for the appellant.
Yes, Your Lordship, for the
Miss-
petitioner.
Oh, this is
Item 18.
Petitioner, huh? Is, raised for by the land council for the petitioner, Miss. And not been objected by the Lana TP. List this matter on, list this matter next day, next week.
Yes, on Monday. then we will-
Okay, list this matter next week on Monday.
And your lordship, it may be kindly reflected in the order that the petitioner may be allowed to peruse the LCR, your lordship.
Along, list this matter on next Monday along with the LCR stuff. Petitioner, whether the petitioner LCR, it is accessible only, I think.
It may be reflected in the order.
Why it is reflected? It is accessible only, I think. LCR, whether order need to be passed.
No,
Not necessary, I
not
think.
necessary. It's not necessary, Lordship. If LCR has been.
Allow them. They can just. You can just see, not necessary to reflect in the order.
Yes, your lordship.
Okay.
Oblige, your lordship.
For admission, item number 35.
Okay.
Lordship,
Yes.
yes, the bail hearing continues. The public prosecutor is supposed to bring on records the progress of the investigation so far done within the period of 40 days by the IO of the case.
What was done?
Lordship, on the last occasion, this honorable court has directed as to whether the present petitioner, they are the main accused or not. So, Lordship, on the last occasion, I have placed this case diary. However, this honorable court has directed to produce another case diary that includes the witness interrogation, Lordship.
Okay,
So-
this is the case where the
Lordship.
person is alleged to have been abducted.
Lordship.
Yeah, my lordship.
Okay, so whether the statement of the.
Yes, Lordship.
Okay.
So, Lordship, I would like to place the updated case diary.
Okay,
Lordship, submitted by the IO.
okay.
So this is the updated case diary submitted by the IO of the instant case, Lordship. This is a case status report. If Lordship may kindly turn to page 2, Lordship.
Phase 2,
Page 2, Lordship.
okay,
Let me
Just a minute.
read from the relevant
just a minute. a moment. Phase 2,
page 2, Lordship.
okay,
Page 2. Relevant paragraph starts from paragraph 6, Lordship.
yes,
If I may allow, Lordship.
please.
During the course of investigation, the complainant, here is the complainant, Dilbar Hussain of New Market, Kohima, was broadly examined under section 161 CRPC, and his statement has found to be fully corroborated with the written FIR. The witness, namely Hussein Ahmad, was thoroughly examined under section 161 CRPC and stated that on 2/10/2023, while he was at his residence in the midnight at around 1230 AM, he got a call from his friend Dilbar Hussain, saying that the accused Amir Uddin, along with some Naga friends, kidnapped his younger brother Anwar Hussain. The taxi driver from Dimapur taxi parking near railway station Dimapur and demanded a ransom amount of rupees 10 lakhs for releasing of his brother, victim Anwar Hussain. And out of fear, Dilbar Hussain transferred an amount of rupees 20,000 in Amir Uddin, accused number 1, through PhonePe. Immediately, he, along with Dilbar Hussain, went to East Police Station, Dimapur, and reported. Next page, Lordship. The victim, Anwar Hussain, was thoroughly examined under Section 161 CRPC and stated that he is a taxi driver of regional taxi Alto bearing number so and so, and presently resident of New Market, Kohima, on 2/10/2023 evening, while he was at Dimapur taxi parking near railway station Dimapur with his regional taxi bearing number so and so at around so and so, one taxi driver, namely accused one Amir Uddin, came along with 4 accused. Very important, Lordship. Came along with 4 accused persons, namely accused number 2. Accused number 2.
Accused number 2 is the applicant here.
Yes, Lord.
My lord,
Accused number 2 is the petitioner number 1, Lord.
petitioner number 1, my lord.
Okay.
And accused number 4, Mabemo Nguli. Mabemo Nguli.
And accused number 5.
And accused number 5, who is the petitioner number 2.
Yes.
Accused number 2. And accused number 6,
Is petitioner number 4.
Longkamar.
6 is also petitioner number 4.
6 is petitioner number 4, Lord.
Okay.
And accused number 6, Aokumba Longkamar, and told him to come near the vehicle Wagner, which was parked at the side of the parking area for some work. So he went with them, and on reaching the vehicle, Wagner are bearing such and such, they dragged him inside the vehicle Wagner and took him to the State Stadium Dimapur near Government College Dimapur, where he was confined. Then he was physically assaulted by those accused persons, namely accused number 2, Ilitang Musui, accused number 3, Lichang Tang Obong, accused number 4, Mabemo Nguli, accused number 5, Mowari Sangtam, and accused number 6, Aukumba Longkumar, who is all the petitioner in this present case, and forcefully snatched his mobile phone and broke into pieces. Later, they rang his brother Dilbar Hussain and demanded a ransom amount of ₹10 lakh for his release, and continuously abused him. After some time, the 6 accused person, so and so, dragged him inside the vehicle Alto K10 and took him to a Sungjim village near Kacharigaon, Dimapur. And after reaching the playground of Sungjim village, Dimapur, they slowed down the vehicle. So he got a chance, and luckily he moved out from the vehicle Alto K10 and escaped for his life. On the following morning, he found the main road and straight away went to Dimapur taxi parking area. And with the help of his taxi driver friends, he contacted to his family and reported at East Police Station, Dimapur, Lordship. So here in this instant case, Lordship, all the petitioner are involved, Lordship.
Yes, we are involved. It appears.
My lord.
When these accused persons were arrested?
The accused persons were arrested on the 3rd of October.
October.
Yes, my lord.
Now, how long they have been
They
inside?
have been in custody for about 40 days, my lord.
40 days. You have filed the bail application, moved the bail application before the trial court.
Before the trial court, my lord, on the basis of medical grounds of accused number 1 only. My lord, I have filed 4 bail applications before the sessions judge at Dimapur on the basis of urgency of medical attention.
It was rejected.
It was rejected, my lord.
On what ground?
Medical contingencies that was
Available in the jail.
My lord, yes.
Okay, then what is the new ground you have taken before this court?
My new grounds are like misrepresentation of facts by the prosecutor at Dimapur. Because my humble contention was whether my arrest has been lawful or not. And they said they did not bring out anything on record. They just said offense has been committed, commit him to judicial custody, let him stay, because it is too early at this stage to release him, considering the investigation that is required to be underdone.
Now, they are
I-
involved, they are involved,
No.
the statement of the.
My lord, they are involved, but what I am, my contention before this honorable court is, I have been misled into all this commission of acts, my lord, because in this case, even the,
No, no,
my
that-
lord, even the informant of the FIR himself is a drug dealer. And because of all this,
maybe.
my lord, the informant of the drug dealer, he has to pay some debts to the accused number one, my lord. And because since he was not paying the debt, they wanted to threaten this, they wanted to threaten in the form of this abduction only. That was a temporary restraint. Now, my humble
So that,
contention is, my lord,
that constitute the crime.
my lord. But there are certain benefit of doubt at this stage to be given according to
No,
my.
no,
present
your
applicant's
involvement
because-
is clearly, you see, stated by the person who has been abducted.
My lord, in the
Ah.
process, within this 4 days time, I have also collected more information from the accused people who are in the custody of the police. I interrogated them personally at the jail, and then I have also collected some information, my lord, which I want to place before my.
What is this information, by the way? Because
Information.
at this stage,
Because but still then, my lord, there are some facts that the honorable prosecution is not presented before this honorable court.
this is a case diary.
Lordship, this is a case diary, Lordship, and under
This is-
section 161 CRPC, Lordship,
This is the statement.
the statement
recorded
has
on
been
161
recorded,
CRPC.
Lordship. How can,
And then as per this case diary, you see, all these accused persons are involved.
Lordship,
Even
all the
the-
accused persons
ah.
are involved, Lordship.
My
So-
lord, my involvement
that
is
faithful
not
date.
denied. My involvement is not denied. But
Then,
Yes,
my
they
lord,
are
but
not
I
denied.
have been misled by accused number one, accused number seven,
So-
accused number one, accused number four, and accused number seven. But the rest of the accused people, I was not aware of these people.
yeah, that is
In
true.
fact, my lord, I was sitting at Dimapur Stadium. I was having some, me and my friends, the present petitioners, we were having some alcohol. In the process, if you would kindly appreciate the statement of accused number one, which I collected from if you would kindly appreciate the statement of accused number one, my lord. Since this accused number one has specifically told me that he has said all these things before the IO in his 161.
I think there is the statement of accused number one
Amiruddin, my lord.
was also recorded by the eye of the case.
My lord, it
Lordship,
is recorded by the
under
IO.
section 161,
Yes.
Lordship.
So this
Statement has been recorded.
accused number one has also informed me while during my, I have taken this liberty to interrogate him from the, in order to consider the facts and circumstances of the,
That will help you during trial.
my lord, that will help me in my trial, but at this stage, my incarceration, my lord, I feel it is quite, at this stage, I have this right to be granted, my lord, or this bail, for that I am before you, my lord.
Yes, but the entire this matter, this case diary probably was also considered and appreciated by the London trial court while rejecting the bail.
Yes, Lord.
And over and again, how do we appreciate the same thing? And then despite, and then from the record, it also, you see, clearly revealed that these accused persons, the applicant, all these applicants are involved. And if you are specifically preying on the medical ground, why don't you segregate the application also?
My lord,
Segregate the application and file on behalf of the person who is, who has a medical problem in the jail, and then that will be different.
Yes,
But
Lord.
then prima facie, there is a case again, there is a, you see, incriminating material against all these accused persons.
Lord.
my lord.
Applicant, I mean.
There are like involvement of the present accused, but they have been misled into acting, into committing all
Maybe,
sex. That is my
maybe, but
humble
then you
contention, my lord.
Maybe, but they are not a minor.
My lord, and
Lordship.
then, if you would, if my honorable lordship would kindly consider,
Hmm.
in fact, if it was kidnapping, then how could accused number one and the informant of the FIR, they could be knowing each other? Even before the act, even before this incident happened, they were having proper phone contact to each other.
Hmm.
And then they have even called this.
That is possible, that is possible.
They have even informed this accused number one, informant of the accused number one is informed, informant of the FIR that he should pay all his debts because since they are having some drug deal between them. So even, but in the process also the investigation officer has done nothing in order to see whether, in order to ascertain whether there have been all these kind of activities that were going on between the, whether all these activities between the informant of the FIR and also the accused number one, accused number 178, accused number 4, and accused number 9. They are all connected. They are all connected into this business. Whereas the present petitioners, they are not directly or indirectly involved in any kind of in this case directly, my lord. That is my
but
at this stage.
But at this stage, we have to consider the prima facie case against the accused.
My lord.
And then from the statement of this person who was abducted, he has clearly stated, and then you see, they have assaulted, they have abducted, assaulted, and then thereafter, they have also snatched mobile and also demanded ransom. So these
And even 20,000 has been paid through GPA.
even my
That is a prima facie.
there's
My lord.
part of ransom has also been already paid.
Lordship.
And then if there is any involvement by the
Part of
accused
the-
number one or the informant, that will attract some other offense, you see. If
Lordship.
there is any involvement, if they are involved in NDPS whatsoever, that will
Lordship.
attract some other use case.
My lord, then the question of
But then for the time being,
my lord, then the question of the informant of the FIR being a drug dealer
anyway,
and the accused people, that is not
But
investigated.
however, in this instant case, Lordship, that has not been affected as far as NTPS other issues.
so here in this case,
Yes, Lordship.
here
However,
in this case, we are
364A is
confined to
serious in
the
serious
abduction
nature.
and the
Lordship.
assault.
Yes, Lordship.
Abduction, assault, and then ransom.
The section that has been attacked against the
Okay.
accused is
So,
serious in nature.
at this stage, I would want to place the judgment of this honorable Supreme Court requesting my honorable court to be kindly liberal in giving bail to the present for accused since they are not
Now,
directly involved in the
it will
case,
be
my
too
lord.
early because it is under still under investigation,
Investigation.
active investigation.
What I'm saying is investigation cannot be stopped. I can continue investigation as long as they want. That is not
Now,
that
it
is-
appears
that
there's so many accused persons, not only these
my lord, that is
present
there. But
applicant, so many
if-
accused persons are also
my
involved.
lord, if you will kindly appreciate the statement
And
of accused
moreover-
number one that is given to me, just one,
Yes,
just one.
what is that?
The statement of accused number one, whether
Accused
it
number one.
corroborates with the statement of 160, whether it corroborates with the 161 statement of the
No, that corroboration.
investigation of officer, my lord, just.
Lordship,
at
the
this stage.
statement,
No,
No,
it's
because
not
I've
going to hold the
also-
water,
that will
Lordship.
help you during trial. That will
I've
help you
also
during
collected some information from the.
No, your information would not help the prosecution.
Lordship,
My lord,
Lordship.
that is-
Lordship has rightly pointed out, Lordship.
My lord, yes.
In a criminal case, you see, your information would not help.
Lordship.
Anyway,
My lord,
yes,
yes, at this stage, I would pray before my honorable lord to be kindly be liberal in granting the bail because they are having personal problems also, my lord, as I have said, and then
yes.
the father of the accused number one also recently passed and the mother is like suffering because of all this and not accused number one, petitioner number one and all this.
Now,
They are like,
if there is say, a case
my lord,
or if any problem, medical ground or any other ground, if you want to take, file separately for the
my lord,
separate
that is
accused person.
my lord.
Now,
But
and then
since the-
here in this case, and probably since you have joined them in the one petition, and then as per the case study, all are involved,
Lordship.
and then
Even the statement of the accused has been
statement of
recorded,
the
Lordship,
accused
and they
also
have admitted. Lordship.
recorded,
Moreover,
they have
They have also
also admitted.
admitted, Lordship.
my lord, moreover, there have been no aggressive confinement in my opinion, like as per the submission of my honorable.
See the
public
statement,
prosecutor,
see the statement
Lordship.
of 161 statement of the,
accused
Lordship.
number
All
one.
the accused, Lordship. They have admitted, Lordship.
okay, yeah.
Yes, Lordship.
This is bail application under section 439. of the Code of Criminal Procedure. The Criminal Procedure Code 1973, praying for grant of bail to the 4 accused persons, namely Elithong Mozue, within bracket A2, Maware Sangtham, within bracket A5, Lee Chantung Obong, within bracket A3, and Aukumba, within bracket A6. Who have been arrested by the Dimapur police
Dimapur police.
in connection with Dimapur East PS case number 247, 2023, under section 364A, 384, 342, 323, 34 IPC. Stop. Para. FIR was lodged after, I think. Okay. The allegation against the accused is that the allegation against the accused as per the FIR lodged by one Dilbar Hussain is that on 2/10/2023 in the evening, while he was waiting for the passenger at Dimapur taxi parking railway station area, along with his brother. Anwar is the
What is the
victim.
victim?
Okay.
What is the
Along with his brother Anwar Hussain, within bracket victim. And at around 8 p.m., he saw Amiruddin, within bracket, Amiruddin came to his brother Anwar Hussain and took him near one private vehicle, within bracket Tata Punch, after which 2 local Naga people came out of the vehicle and put Anwar Hussain, victim, inside the vehicle forcefully and fled away. And after a few minutes, the said 2 local Naga persons came in the scooty. No, after a few minutes, two local Naga persons came in a scooty and took his taxi vehicle bearing registration number, number NL OIT 9891 within bracket Alto 800 standard stop. And later on, at around 8:30 p.m., one unknown person called him in his mobile from Anwar Hussein's mobile, within bracket, victim mobile, and asked him whether Anwar was his brother or not. And the unknown person, unknown person, leave that and ask him, demanded rupees 10 lakhs from him for release of his abducted brother, or else they will kill his brother. Stop. And out of fear, he told the unknown person that he will pay rupees 20,000 from his mobile, and rest of the amount will for rest of the amount he will come and hand over to him. Stop. Then he paid rupees 20,000 in Amiruddin's phone pay. And thereafter went to East Police Station, Dimapur, to report the incident. Stop. Para. The Learned Counsel for the petition of Mr. submits that all the accused persons, accused applicant, are innocent. They have been misled by
Misled, my
the
lord,
accused
misled.
number 1, Mr.
By accused number 1, accused number 4, and accused number 9, my lord. That is
Accused
my
number,
humble
accused
submission.
number 1, Mr. Accused number 1. What is the name of the accused number 1?
Amiruddin,
Amiruddin, comma, accused number 4.
accused number 4.
Who is accused number 4?
Mabemo, accused number 4.
Mabemo Nguli,
Yes.
and
Accused number 9.
accused number 9.
My lord.
What is his name?
Zareni Muli.
Jahiran Nguli. And what is your other submission?
My lord, if you will come to para number 8 of my petition, my lord. Para number 8, my lord. Everything revolves around accused number 1 and the informant of the FIR, since they have been related from before. And accused number 9, even before going to abduct the person, the accused
Where do I find that?
Yes.
Where do we find that?
No, my lord. In para number 8, my humble contention is, my lord, that from the facts of the given FIR, prima facie, it appears that the victim and the informant of the FIR are well acquainted.
Okay. And
Because-
he further submits that the
Yes.
victim or informant? Informant only, not the victim.
The informant, the victim
Okay,
and the informant.
Further
Victim
submits
also,
that
informant also.
the informant of the present case and the accused number
1.
1
Mm.
are
Well
well
acquainted.
accounted even prior to the alleged incident.
My lord, yes. Mm. Even before this incident on the same day, my lord, since the incident occurred around 8 to 10
Stop.
p.m., around 7 PM.
Hmm.
The informant of the accused number one is even called up.
Okay.
The accused number one is even called up because that is given in the statement of accused number one, according to him, in statement 161.
But then
My lord.
what is your allegation that they are falsely implicating this applicant?
My lord, they're falsely implicating.
And as such,
the present
and as
four
such,
applicants.
and as such, the
Right.
present accused applicants have falsely been implicated by the informant and the accused number one. Stop.
And moreover, everything revolves around, the entire incident revolves around accused number one and the informant of the FIR. Because my lord, if you would continue with para number 8 of my submissions, my lord, in the bail application. What I want to, my humble contention is, my lord. Around 8, as per the in the FIR, it is mentioned by the informant of the FIR that around 8 PM, I saw Amir Uddin, who came to my brother Anwar Hussain. They already know each other from before, my lord.
That is
My lord. And also,
Okay.
one person took away my taxi vehicle bearing registration number NL01T9891, wherein as per the property search and seizure form also, the said taxi has been recovered from the hands of accused number one only, my lord.
And further, that the taxi which is alleged to have been taken away by two Naga people. have
By
all-
the informant of the FIR, by the accused number one, my lord.
the accused number one took
Accused
away.
number one took away the taxi.
Okay.
my lord. Yes,
Uh,
along with the help of the
and-
two Naga people.
Okay. The taxi which was taken away, which is alleged to have been taken away by two Naga people and the accused number one, have also been recovered
Recovered from the hands of the
from
accused number one.
the possession of the accused number.
Possession of the accused number one.
Accused
As
number
per the
one.
property search and seizure form submitted
Accused
by the
number one.
police.
Stop, huh? And as the present accused applicant have falsely been implicated by the informant and the accused number one, they
Moreover, even in the given FIR, my lord, it is mentioned that some unknown persons demanded rupees 10 lakhs from me and for release of my brother, or else they will kill my brother. And out of fear, I told the unknown person that I will pay rupees 20,000 in Amir Uddin's phone pay
and hence
number.
pray for their release, huh? Stop, huh?
My lord.
Okay,
They'll-
stop, huh?
Mm.
Okay. Para, huh? The Lanet PP, Mr. Produced a scanned copy of the case diary. And I have perused the same stuff, huh? As per the case diary, comma. And as per the record, stop. Comma, as per the record. It appears that all the accused applicants are found involved in the instant case for abduction of the victim Anwar Hussain for ransom on 2/10/2023. Stop, huh? The statement of the victim reveals that the accused A to all the accused applicant, namely Elithong Mozu, Moware Sanctum, Lichantung Obom, and Akumba are involved in his abduction on 2/10/23. And the accused persons had physically assaulted the victim, his mobile phone has been broken into pieces. And later on, and he was confined. And he was, the mobile phone was forcefully snatched and broken into pieces. And he was confined, and later on, the accused person also demanded ransom amount of rupees 10,000 from his
10 lakhs.
brother, 10 lakhs from his brother. Stop. Stop. Para, heard both the land counsel for the petition of Mr.
Sorry for the indulgence, Lordship.
Yes, sir.
I just want to add one more point, Lordship.
Mm.
Since the petitioner counsel is saying that the accused number 4, accused number 1, and accused number 1 has misled them.
Mm.
But if you go to the statement of accused number 4, Lordship, page 6, Lordship. If Lordship may kindly come to page 6 of the case diary, Lordship.
Mm.
Page 6.
Accused number 4.
Page
Yes.
6. 1, 2, 3, 4, 5 paragraphs.
Yes.
At around, if I'm allowed to read, Lordship,
Yes.
to make it more clear. At around so hours, he along with 3 accused, this is the statement of accused number 4. He along with 3 accused persons, namely accused number 2, Ilithang Muzi, accused number 5, Morway Sangtam, and accused number 6, Aukumba Longkumar, who is the present petitioner here, moved from State Stadium, Dimapur, from his vehicle Wagner, and together they proceed to Dimapur parking area. On reaching the location, they meet accused number 1, Amir Uddin, accused number 7, Iqbal Hussain, accused number 8, Imran Hussain, and accused number 9, Zarin Muley. After that, they were searching for victim Anwar Hussain at taxi parking area. Then the accused number 1, Amir Uddin, showed them the victim Anwar Hussain roaming around the around the taxi parking area and directed them to abduct from the spot. So he, along with the accused person, accused number 2, Ilithang Muzi, accused number 5, Morwe Sangtam, and accused number 6, Aukamba Longkuma, called the victim Anwar Hussain and dragged the victim inside his vehicle Wagner at the backseat, Lordship. This is a statement of the accused number 4. Now the petitioner counsel is saying that the accused number 4 has misled them.
My lord.
But if we go to if we examine from the statement recorded by under section 161 CRPC by the investigating agency, it is mentioned that accused number 2 and accused number 5 and accused number 6, Lordship, who dragged the victim, Lordship.
My lord.
And moreover, Lordship, if Lordship may kindly come to page 13 of the case diary, Lordship. I will only read the relevant. This is the statement of accused number 9, Lordship. Page 13, Lordship.
Yes.
Page 13. 1, 2, 3. Third paragraph. Meanwhile.
Yes.
Lordship, I will only read the last 3 paragraph, Lordship. Last 3 paragraph from on the following night. Lordship, I've got it.
From?
On the following night.
On the following.
Meanwhile,
Yes. Okay.
on the following night, at around so and so hour, the three accused person, Amir Uddin, Ilithang Muzeu, who is the accused number 2, petitioner number 1, and Lichangtang Ovong, who is the accused number 3, petitioner number 3, took the victim car Alto and left the confinement place to receive the remaining cash from the victim's family, Lordship. So they are all involved, Lordship.
How I come, my lord, how I come to be involved is not being read. He's
This is a statement.
How I come to be involved is very important, my lord.
So, before hard, on the other hand, the Lana PP submits that from the statement, from the police statement of the accused number 4,
Yes, Lord.
and one is 9.
Accused number 9.
9. It is clear that all the accused applicant are involved in the abduction, assault, and demand of the ransom from abduction and assault of the victim, and also in demand of ransom in return to ransom of rupees 10 lakhs from the informant in return of the abducted victim stuff. Then that comes on. See, hard, Then upon hearing the parties and considering. No, just a minute. I perused the CD. It has recorded.
And moreover, the nature of the
carefully
offense
perused the
is serious in
CD.
nature.
Upon hearing the parties and on consideration of the case diary produced before this court and considering the case diary before this court, I found that there is a prima facie there is an incriminating material against the accused and all the accused applicant for their involvement in commission of the alleged offense. And as the case is still under the national stage of investigation, I am not inclined to grant bail to the accused applicant at this stage. Stop. Accordingly, this bail application stands rejected.
Hello.
Bless my lord.
For orders, item number 19 and 20. Item number 19 and 20.
May it please your lordship.
Yes.
Lordship, I am appearing for the petitioner on item number 19 and 20.
Sorry.
Lordship,
Just a minute, please. She was not clear. There was something in the middle. Call it. Call. Okay.
Item number 22.
Yes.
May I please, your lordship?
Yes.
Your lordship, I pray this matter may be listed along with item number 18.
Item number 18.
Yes, your lordship. What
Item num-
pertains to the same issue, your lordship,
Item
arising
number
out of the
18,
same FIR?
18 is fixed on
On Monday?
Monday.
Yes, your lordship.
Okay.
However, your lordship, in item number 22, it is stated that LCR is awaited in the cost list.
Yes. Then
So,
on Monday also, if the LCR doesn't arrive, then it will be difficult.
your lordship,
We'll
LCR
say
may be
next-
called again then, your lordship. Because Dimapur is just nearby. So I believe it will be not so difficult to send the LCR,
Okay.
your lordship.
You are for,
I am for the petition.
Miss, you are,
Vitere.
okay, wait here. Our land council for the petitioner, Miss Bitaria. She submits that in the instant case, the LCR is still awaited. And prays for issuance of reminder for the LCR stuff. Issuance of reminder for the LCR and to list after receipt of the LCR, or what?
Sorry, your lordship.
This will be placed only after receipt of the LCR only.
Your lordship, it may be listed along with item number 18
Along with,
on Monday.
oh.
your lordship. I believe by the
Ah.
time LCR,
Okay, submits that in the instant case, the LCR is still awaited. However, she prays for listing the present matter along with the
item number
item
18.
number 18. 18 is,
Both these matters pertains to the same issue, your lordship.
pertains to similar matter.
Yes, your lordship, arising out of the same FIR.
Okay.
Your lordship.
Is item 18, write the name of the case, criminal petition 2923 is both the present case and the criminal petition number 29/2023 as arising out of the same
FIR. Your lordship.
FIR
Yes.
stuff. List this matter next week along with the criminal petition number 29/2023.
Yes,
Okay.
your lordship. Yes, your lordship.
Okay.
Item number 19 and 20.
May it please your lordship.
Yes, please.
Lordship, I am appearing for the petitioner ICICI Lombard. Here I have filed a miscase for restoration of the miscase that was dismissed for default. Notice was issued on the last occasion. And I have taken the steps accordingly, Your Lordship.
Okay. Whether notice return, service or notice issue upon still, a notice is still awaited. So. Okay. How many respondents are there?
My lord, only
Two.
respondents, my lord.
Oh, so, two respondent.
Yes,
Okay.
ma'am.
Heard land council for the. Heard Ms. S. Kakati,
Yes, my lord.
land council for the applicants. The notice was issued. However, the service report is still awaited. When the notice was issued, just a minute, the notice was issued on 18/10.
Yes, ma'am.
2023. However, the service report it is still awaited. Stuff in view of the above, list is matter after 2 weeks.
Any time, my lord. Only, my lord. A date may be fixed, my lord. Kindly.
Okay, date, when do you want?
As per the convenience of the honorable court, my lord.
Okay. 28, 28, huh?
My lord.
List is matter on 28. As prayed for by the land council for the applicant, comma, list is matter on 28. Okay. Yes.
May I please, Your Worship?
Yes.
Your Worship, with apologies, I beg to mention hearing item number 25, Your Worship.
Item 25.
Yes, Your
What
Worship.
is the,
I'm appearing on behalf of the private respondent 2 and 3, Your Worship. The senior counsel is indisposed, Your Worship, and I pray that this matter may be listed after 2 weeks, Your Worship.
so, no, okay.
No objection.
Learned advocate, Mr.
Zakul,
appearing on behalf of,
respondent 2 and 3. Private respondent 2 and 3.
okay, private respondent number 2. Your counsel or appearing, appearing
Yes.
for, okay,
I'm also a counsel, but
okay, that's fine. Praise for,
2 weeks time.
okay, 2 weeks time. Stop, huh? Leonard, you are here, MSC. You are for the petitioner.
Yes, Lord.
Leonard, Mr. Angami, Leonard counsel for the appellant is also present. Stop, huh? Is also present and has no objection to the prayer for adjournment made by the land council for the petitioner. Stop. Accordingly, the prayer is allowed. List is matter after 2 weeks. Okay.
Much obliged.
For hearing. Item number 24.
May it please, Your Lordship.
Yes.
Lordship, the instant matter is filed under section 173 of the Motor Vehicle Act, Your Lordship. Going for squashing of the order dated 22/10/2019, Your Lordship, passed by the learned tribunal claims Mokjong, Your Lordship, in MSC case number 43 of 2027, Your Lordship. Lordship, if the LCR is here, Your Lordship, the matter can be heard, Your Lordship. Just a short matter, Your Lordship.
Just a minute. Huh?
Here there are two responses, Your Lordship, respondent 1 and 2, Your Lordship. For 1, the senior counsel is appearing, Your Lordship, and for 2, notices have already been completed, Your Lordship, for respondent number 2, Your Lordship.
This is LCR. Okay. So the respondent has filed. Any objection?
No, Your Lordship, they have not filed.
Have you filed any objection?
No, Lordship. Matter.
No. So oral
Yes.
submission. Okay. Just a minute. Huh? Okay, 50% also deposited.
Yes, Your Lordship.
Already deposited. Okay, yes, what is your case?
Lordship, just praying for squashing of the order, judgment and order
Yeah.
dated, your lordship. The award awarded to the claimant, your lordship.
You are for
The appellant, your lordship.
appellant is
Surya Borwa, your lordship. That's the claimant, your lordship.
for, you are for appellant,
Yes, your lordship. The appellant is for
Assistant Manager.
HDFC, your lordship.
HDFC. And then the respondent is Surya Baro is a private respondent.
Yes, your lordship. The claimant, your lordship.
Surya is a claimant. And then who is this respondent number 2, Ajay Shankar Pandey?
The driver and the owner of the vehicle, your lordship. Alleged.
Is the owner of the vehicle.
Yes, your lordship.
Whether the owner of the vehicle is represented,
No, your lordship, but your lordship, notice have already been completed, your lordship.
completed.
Yes, your lordship.
Whether the notice
Your lordship, it
has been
been
treated as
recorded, your lordship.
completed.
Yes, your lordship.
Where do we find this order? Let us just see.
19/7, your lordship, 2022, your lordship.
19/7.
7/2022.
Twenty 22.
Yes, your lordship,
Okay.
22, your lordship.
Order of 2022.
Yes, your lordship. 2022.
It is not available here. 22 is not available here.
Okay.
11. It starts from 1411. Oh, just a minute, 19/7. And oh. $19/7 is limitation. Just a minute. This is on limitation.
Yes, your lordship, the order is recorded on limitation, your lordship, IA 52,
Just a minute.
35 of 2000.
Okay. Okay, then what is case, your case?
Lordship, for squashing, your lordship, if I may be allowed to brief the facts of relevant facts of the case, your lordship.
Yes.
Lordship, what has happened is that on 28/04/2017, your lordship.
28.
For 2017, your lordship.
Have you given a list of date? No list of
Your
date.
lordship would come to. Page two, your lordship.
Page
Page two, your lordship.
two,
Para two, your lordship.
there are two.
Yes, your lordship. Lordship on 28/04/2007 at around 4:30 AM, your lordship. A
Just a
vehicle,
minute, huh?
your lordship, a vehicle bearing registered number AS07J, your lordship. 0666, your lordship. Chevrolet Beat car, your lordship. Driven by the respondent number 2, your lordship, who is the owner and the driver.
Petition,
Lordship.
Register, vehicle register,
AS07J0666, your lordship.
okay,
Lordship met with an accident near Gauhati bypass road and collided with two guard posts of the road and rolled below the road, your lordship. Lordship here, the claimant, the respondent number 1 here, your lordship, was the occupant, your lordship, the passenger of the instant accident car, your lordship.
respondent number 1,
Yes,
who
your
was it, driver?
No, your lordship, the occupant, your lordship, the passenger.
The respondent number 1 is, was the passenger.
Yes, your occupant, your lordship.
Hmm.
Lordship, accordingly, the occupant, your lordship, respondent number 1 filed MSC case 14, MSC case number 43/2023, your lordship. Under learned tribunal Mokchong, Nagaling, your lordship. Lordship, well, your lordship here by filing the instant MSC case, your lordship, the respondent.
So this respondent number 1 file,
Yes, your lordship.
MSC case,
Yes, your lordship. 43/2017, your lordship.
43,
43, your lordship. 43, your lordship.
it's in the para 2.
Yes, your lordship. Lordship claiming a compensation of rupees 34,90,400 rupees, your lordship.
Okay, where do we find that?
Lordship, page number 4, your lordship.
Rupees. Okay. Page number 4, para.
If your lordship would come to the make appeal, your lord, tribunal case 43/2017, your lordship.
Okay, where?
MSC 43, your lordship, filed by the claimant, your lordship. The
MSA?
43/2000, your lordship. Under the landed tribunal Mokchong, Nagaling, your lordship.
Page
Lordship, page number 7, your lordship.
7.
Yes, your lordship. Of the MEC 43, your lordship, 2017.
What is this? Page 7 of your
No, your lordship, of the MSC case 43.
MSA?
43, your lordship, filed before
Oh,
the
case record.
tribunal Mokchong. Yes, your lordship.
But just a minute, huh? Let me check this. 7. Okay,
7, your lordship. Yes,
43, page 7.
yes, your lordship.
Yes.
Compensation of 34,90,400 rupees, your lordship, was claimed, your lordship.
34.
Yes, your lordship, 34 lakhs, your lordship. 90,400, your lordship. Lordship, with interest of 12% per annum to the amount, your lordship.
Interest
12%, your lordship.
12.
Yes,
Okay.
your lordship.
Hmm.
Lordship, what has happened here is that the driver as well as the insured company, your lordship, was met a party, your lordship. And all the parties have met their written statement in your lordship. The matter was contested, your lordship. Issues was framed by the tribunal, your lordship. And on 22/10/2019, your lordship, an award amounting to rupees 9,80,000, your lordship, was directed to pay to the to the claimant, your lordship, within 30 days, with interest of 9% per annum from the date of filing of the claim, your lordship.
So where is the judgment? Where is the award?
Your lordship would come to my appeal, your lordship. Page number 15, your lordship.
Page number
15, your lordship. Annexure B, your lordship.
15.
Your lordship. Relevant
It has not been paging, just a minute, huh? 9, okay, this is extra. 10. $15.
Yes, Your Lordship. And next should be Your Lordship. That's the copy of the judgment on order date. Your Lordship, come to page.
Just a minute, huh? Judgment. Okay, page
18, Your Lordship, last portion, Your Lordship. Yes,
Okay.
Your Lordship.
So his claim was 34
Yes, Your Lordship.
lakhs,
And
and then the award is
9,80,065 rupees, Your Lordship.
9 lakhs.
Your Lordship, with interest of 9% per annum from the date of filing of the claim, Your Lordship.
Also, the interest claim was 12%.
Yes, Your Lordship, 9%.
The claim was 12%.
Yes, Your Lordship.
And then the award is 9 lakhs,
80,000, Your Lordship.
30,000 with 9%.
Yes, Your Lordship.
Hmm.
Lordship, hereafter, Your Lordship, the appellant, the insured company being aggrieved, Your Lordship, I filed the instant petition under section 173 of the Motor Vehicle Act, Your Lordship. Lordship, I just have limited grounds, Your Lordship.
Yes,
Just 4 grounds, Your Lordship. I'll be pressing on just 4 grounds, Your Lordship.
okay.
Lordship, the first ground is that the learned tribunal has failed to prove the rash and negligent driving of the vehicle, insured vehicle, Your Lordship, by adducing proper documents, Your Lordship. By producing proper document, Your Lordship, the
Producing
tribunal-
proper?
without producing proper documents. Your
Okay.
Lordship. Lordship. The second ground would be on that no proper.
So your ground is at page
Lordship.
6.
Yes, Your Lordship. Just limited grounds, Your Lordship. I'll be pressing on just limited.
Your ground, what you're submitting is in ground number?
Ground number, page number 5, Your Lordship.
Yes.
Serial number K, Your Lordship.
K.
Serial number K, Your Lordship.
Okay, okay.
For that, the learned member Motor Accident Claims Tribunal, Mokshung Nagaland, has failed to take into consideration that the medical doctors who issued the treatment and disablement treatment certificate were not examined to prove the authenticity of the exhibit. So also to reveal the nature of injury sustained by the claimant as provided under provision of section 142 of the MV Act 1988, Your Lordship.
Okay.
And Your Lordship, further that the medical grounds was issued, that the medical doctors who issued the treatment and the disability certificate issued were not proved, Your Lordship, during the time of the trial, Your Lordship. Tribunal.
Medical officer was not examined.
Yes, Your Lordship. No, besides the doctor, Your Lordship, no witnesses were even examined, Your Lordship, at the tribunal, Your Lordship, at the stage of the tribunal, Your Lordship. Lordship, if I may be allowed to furnish few authorities, Your
No,
Lordship.
this is in this point.
Yes, Your Lordship.
Okay, what is that?
Relating to the grounds, Your Lordship, to the 4 grounds, Your Lordship, which I've just mentioned, Your Lordship. Lordship, coming to the first ground, Your Lordship. Serial number 1, Your Lordship. 1 and 2 deals with the rash and negligent driving of the insured vehicle, Your Lordship, by adducing proper documents, Your Lordship.
Relevant portion?
Yes, Your Lordship. Para 22, Your Lordship. Lordship, if I may be allowed to.
Para 22.
Yes, Your Lordship. If I may be allowed to read it, Your Lordship.
Just a minute, huh? Yes.
Your Lordship, here in some case, Your Lordship, no, it was not proved that there was rash and negligent driving on the part of the driver, Your Lordship, and hereby the past is instant judgment, Your Lordship. Your Lordship, if I may be allowed.
Whether in the instant case, whether the criminal case was also
Yes, Your Lordship.
filed.
Yes, Your Lordship.
What is the result of the consequences of the criminal case?
Your Lordship, in my matter, Your Lordship, no FIR or no criminal case was
Registered.
Registered. No criminal case was registered, Your Lordship.
217, no
Yes,
criminal
Your
case was registered.
Yeah, Your Lordship, the lemon have just sustained 25% disability, Your Lordship, and
Okay.
there was no death, Your Lordship.
Okay,
Lordship, para 22, Your Lordship.
there are 22, yes, read.
Just the relevant portion, Your Lordship. Keeping in view of the facts and circumstances of the case, and on parcel of the records, I am of the view that the prosecution has failed to prove beyond reasonable doubt that the conduct of the petitioner was rash and negligent driving, and the petitioner is guilty of having committed offense under section 304A279 IPC by causing death of the victim, Your Lordship. Your Lordship, here in the instant side, authority, Your Lordship, there was death, Your Lordship. However, in my matter, there is no death, Your Lordship.
In the instant case, only injury,
Yes, Your Lordship, 25%, just 25% injury, Your Lordship.
25%.
Your Lordship,
Where do we find that 25% injury?
Lordship, from the LCR, Your Lordship, from the case report. Page number 32, Your Lordship, of the MSC case 43 of the 2027.
In your appeal, you have not
No, Your
mentioned,
Lordship, MSC case 43 from the case report, Your Lordship.
in the appeal, you have not,
Your Lordship, I have not annexed the disability certificate.
okay. But in your ground also, you have not mentioned
Yes, Your Lordship,
that page.
32, Your Lordship.
Thirty?
32, Your Lordship.
No, there is only up to 32. There is no page 33. Sorry. This is only up to page 32. Oh, then why? Just a minute, huh? Oh, it has come again, yeah, 32 only. Then inside there is again page 32. 33 in Assamese.
No, Your Lordship, it's the
Inside
OPT ticket, Your Lordship, issued by the government.
This is, I think, how it is. 23. How it has been paginated. It starts from 15. 33 is some Assamese written, some other language, Assamese or some other language. Is this the one? This is 32. Okay.
Lordship, the OPT certificate, Your Lordship.
Yes, OPD.
Lordship, here, diagnosis, Your Lordship, fracture of the last humerus with radical nerve, Your Lordship. Percentage disability at the moment, Your Lordship, it was 25, Your Lordship.
Yes,
Yes, Lordship. Your Lordship, coming back to the judgment, Your Lordship.
just a minute, huh? Just a minute, huh? This is ground number 1.
Yes, Your Lordship.
Just take now. Okay, okay. Yes, this is. In the ground number 1, This is your ground number K is ground number 1.
Your Lordship, Your Lordship.
Okay. And in that, this 2018 SCC online. Okay. K. Not K.
Next, Your Lordship, apologies,
Just a
Your
minute.
Lordship. And
I need to-
serial number B, Your Lordship, the grounds, under the grounds, Your Lordship.
Hmm.
Page 3 of my McApee, Your Lordship.
Just a minute. Just a minute. Just a minute, for the land. Has failed to take. Okay. That's it. Just drop this once now. Yes. Grounds. Okay. 1. That the MACT Mokokchung Nagaland has failed to take.
Your Lordship, apologies, Your Lordship, regarding the grounds, Your Lordship. If Your Lordship will come to ground number B, Your Lordship, of my.
Not the K.
B, Your Lordship. K will be referring to ground 2 and 3, Your Lordship.
K would be ground 2 and 3.
Yes,
Three.
Your Lordship.
So ground 1 is
Serial number B, Your Lordship,
Because
page number 3.
you
of
need
my
to record it. Let's just your submission. I want to record.
Lordship.
Ground B.
Page 3, ground B, Your Lordship.
B.
Yes, Your Lordship.
Grounds, that the Lanan MACT Mokokchung Nagaland has failed to take into consideration that the claimant has failed to prove the negligent driving of the insured vehicle within bracket bearing register number AS07 J/0666 Chevrolet Beat car, bracket close, by adducing proper evidence, comma, thus the finding of the learned member, comma, MSc, CT, comma, Mokokchung, comma, Nagaland, and in making the award cannot stand the test of law. As such, the same is liable to be quashed and set aside. Any ruling here in this case?
Lordship.
So this, okay, this is ground 1.
Yes, Your Lordship.
Okay, then ground 2 would be K.
Yes, Your Lordship.
K is your ground 2.
Yes, Your Lordship. Regarding medical doctors, Your Lordship, examination of medical doctors.
Okay, ground 2, So that that the MACT Mokokchung Nagaland has failed to take the consideration that the medical exam doctor who issued the treatment and disablement certificate were not examined to prove the authenticity of the exhibit, so also to reveal so as to reveal the nature of injury sustained by the claimant as provided under the provision of section 142 of the MB Act 1988. The Land Council further submits that as per this is medical certificate, OPD ticket is not a medical certificate.
Yeah, Your Lordship, they have just issued, produced this one, Your Lordship, as disability certificate, Your Lordship.
This is not a certificate.
Yes, Your Lordship. No proper disability certificate was produced, Your Lordship, before the tribunal, Your Lordship.
Okay. The Land Council for the appellant submits that the medical document produced by the claimant Exhibit P13. As per the medical document produced by the claimant, the percentage of disability of the claimant at the moment was 25%. No?
Lordship,
25%.
25%.
Okay. And then you this.
The Lordship would come to serial number 1, Your Lordship, of
No. So
the
so this is
citation, Your Lordship.
this is the citation
Yes, Your
here
Lordship.
for this point.
Yes, Your Lordship.
Okay. Para.
For racial negligence.
In this para, in this this is
For ground one, Your Lordship.
for ground 1.
Your Lordship, the authorities furnishes 1 into Your Lordship. Serial number 1 into Your Lordship. Your Lordship, I flag it as 1 into Your Lordship.
The 1.
Yes, Your Lordship.
1 is for ground number.
Ground 1, Your Lordship.
Ground 1. Okay.
Lordship.
In the ground 1 earlier, the Land Council for the claimant has taken reliance upon the decision of the Supreme Court.
Your Lordship, Delhi High Court, Your Lordship.
So Delhi Court, Delhi
Yes,
High
Your
Court of the
2008.
High Court, so decision of the High Court of Delhi, and the Delhi High Court, this in 2008. In case it is not reported one.
2018
In
SEC
case
online
number
Delhi.
2018 SEC online or online,
Online Delhi, Your Lordship. 12337.
online Delhi 12337.
Your Lordship.
Within bracket, Kishore Chand Joshi versus state. Stop, bracket close, okay. And
Lordship, coming to serial number.
just a minute, which,
Para 22, Your
The,
Lordship, of
the relevant portion. Relevant portion is quoted here below, quoted here. Quoted is under, within bracket, para 22, you have to type, okay.
Coming to the next
Okay.
authority,
yes.
Your Lordship.
Okay.
Serial number 2, Your Lordship, of the list of authorities.
Serial number 2,
Your Lordship.
okay, this is in ground number,
Your Lordship, this will be also be in ground 1, Your Lordship. Racial negligence.
Ground
Your
1.
Lordship.
okay.
Lordship, relevant para would be in para number 10 and 11, Your Lordship.
10 and 11,
Lordship.
what is, let us read.
Lordship, before that, Your Lordship, if your Lordship would come to the first page, Your Lordship. The
Yes,
coastal, Your Lordship.
hmm.
If I may be allowed to read it, Your Lordship.
Please,
Racial negligence driving, Your Lordship. Contributory negligence.
para,
Your Lordship, the first
Introduction.
portion, Your Lordship.
okay,
May involvement of vehicle in accident, health cannot fasten liability to pay compensation unless racial negligence act of the driver can be proved. On facts held, since a bus was standing at a red light and could stop within 100 to 150 yards of traffic signal on being asked, it cannot be said that the bus started at high speed. Besides, PW2, who was reliable witness, stating that despite no signal being given, but the driver was by the bus driver to overtake the bus, this is motorcycle in effort to overtake the bus had gone on its right. Lordship, the relevant part, Your Lordship, thus help racial negligent driving by the driver, respondent number 2, not proof, no interference with the impugned judgment, setting aside of tribunal, granting 274,000, compensating along with interest, rate of 12% called for, Your Lordship. Lordship, coming to para number 11, Your Lordship. Lordship, it was held that in the facts of the case, it is not found possible to accept the contention on behalf of the appellant claimant that the accident was on account of racial negligent driving by the driver. Respondent number 2, by the driver, respondent number 2. In that view, the matter is not found possible to be given any relief to the appellant, Your Lordship.
Okay, this is just a minute. The fact is stated in para 10.
Your Lordship, facts in 10 and the order pass in para 11, Your Lordship.
Okay, so, and then the fact is stated in para 10 only.
10, your lordship.
Where do we find the relevant one?
Your lordship,
Can't type it all,
10, your lordship.
entire 10.
Yes, your lordship.
Okay, then, the Rani Council also taken a reliance upon the decision of the Supreme Court this is reported one.
Yes, your lordship.
In 2014, 13, SCC 254. The relevant portion is stated, reproduced here in below, stock para 10 and 11, Okay, this is in ground one
Ground
only,
one, your lordship.
Okay.
Lordship. Coming
So-
to the next one, your lordship,
Hmm.
regarding no proper disability certificate was found on the court, your lordship.
So that is, your ground
Ground number
2,
yes, your lordship.
In-
And ground number K
in
in
K.
my MSc McAfee, your lordship.
oh, sorry, not K. Ground number K is,
Regarding doctors and disability.
oh,
your
sure,
lordship,
K,
it's relevant,
K,
your
ground,
lordship.
K
Yes, your
is
lordship.
ground number 2.
Yes, your lordship.
Okay, ground number 2, Have I dictated? No,
No, your lordship.
ground 2, not, no, okay. That 2, you said 2, that the non-member MSCT Nagaland, Mokokchung Nagaland has failed to take into consideration that the medical doctor who issued the treatment and disablement certificate were not examined to prove the authenticity of the exhibit. This I have already dictated so as to reveal the nature of injury sustained by the claimant as provided under the provision of section 142 of the MB Act 1988. This we have already dictated. Okay, we hear any ruling?
Yes, your lordship. Your lordship, if your lordship would come to the serial number 3, your lordship.
Okay, the land same, the land council for the claimant has taken reliance upon the decision of the Honorable Supreme Court decided in
2011.
2011 1 SCC 343. The relevant portion,
Portion 16, 17, 18, your lordship.
the relevant portion are reproduced here in below within bracket. Para 16. Para 16,
17,
17,
18, your lordship.
and 18. Let us read. What is this?
Your lordship, if I may be allowed to.
Yes, please.
Para 16, your lordship.
Hmm.
The tribunal should not be a silent spectator when medical evidence is tendered in regard to the injuries and their effect, in particular the extent of permanent disability. Section 168 and 169 of the Act make it evident that the tribunal does not function as a neutral umpire, as in a civil suit, but as an active explorer and seeker of truth who is required to hold an inquiry into the claim for determining the just compensation. The tribunal should therefore take an active role to ascertain the true and correct position so that it can assess the just compensation, your lordship. Lordship, coming to para 17, your lordship. If a doctor,
Just a minute, up to this, na?
just compensation. your lordship.
So 16 up to compensation, I have marked it, Okay,
Para 17, your lordship.
para 17.
Lordship.
Yes,
If a doctor giving evidence use technical terms and the tribunal should instruct him to state, in addition, in simple, non-medical terms and the nature and the effect of the injury. If a doctor gives evidence about the percentage of permanent disability, the tribunal has to seek clarification as to whether such percentage of disability is the functional disability within reference to the whole body or whether it is only with reference to a limb. If the percentage of permanent disability is stated with reference to a limb, the tribunal has to seek the opinion as to whether it is possible to deduce the corresponding function disability, permanent disability with reference to the whole body, and if so, the permanent, so as to do the percentage.
okay.
Lordship, in the instant matter, what has happened is that no medical doctors were called for your lordship.
And your percentage that was recorded by,
Yes, your lordship.
that is in this point only?
Yes, your lordship. Referring to this point also, your lordship.
Okay.
And your lordship, if
So-
your lordship would appreciate that the medical certificate, the OPD certificate issued to the claimant, your lordship, was by a different doctor, and the treatment taken was on by different doctors, your lordship.
Okay. So the earlier this on the 25
Yes, your lordship.
is in this point.
Yes, your lordship.
And submit, the land council for a petition submits, in the instant case, the medical document submitted by the claimant and exhibited as exhibit P13 this is not a certificate.
Not a certificate,
Is-
just an
is-
OPD ticket, your lordship.
Is an OPD ticket and not a medical certificate.
Lordship. Your lordship, no. medical
Not a
doctors-
medical certificate of this, not a medical certificate issued by the issued after the treatment.
your
or
lordship,
what
after
we-
the treatment.
Hmm?
Yes, your lordship.
Certificate, stuff, and as per the diagnosis, the percentage of the disability of the claimant at the moment was 25%. And further, this certificate was
Issued by a completely different doctor, your lordship.
issued
the
by a
doctor
issued by completely a different doctor
Your lordship,
and not by
your lordship would come to page 32, your lordship, the OPD certificate.
and
OPD certificate.
yes.
It was issued by Dr. Impoklipa Memorial District Hospital, your lordship, Mokjong, your lordship, Nagaland. Lordship, and if your lordship would come to the previous clinical reports, laboratories, and all the treatments, your lordship, the receipts and all.
Issued by Dr. Imkomlimba Memorial Institute Hospital, Mokokchung, Nagaland, and not by the doctor who has treated the claimant
Yes,
at,
your lordship. Your lordship, regarding that, the next citation is relevant, your lordship.
who treated the claimant?
Lordship, it's
earlier?
not specific here, your lordship. What they have mentioned in the MAC April 42 of 2017 is that several doctors have treated the claimant, your lordship.
Okay, no,
No specific doctor has been given, your lordship.
Acha.
But the OTP certificate, the disability certificate was from a completely different doctor, your
okay,
lordship.
and not by the doctor who has initially treated the
Treated, your
claimant.
lordship. Your lordship would come to the next.
Okay.
Table, your lordship, it's more
Okay.
relevant to the point, your lordship.
Okay, just a minute, this will complete this portion.
Your lordship,
So, para 16 and 17, we have
lordship.
noted, na? Para 16 and 17 of that, Delhi decision and 18 also,
Your
para
lordship,
18 also.
your
Is
lordship,
is it relevant?
lordship, somehow relevant, your lordship, but if 16 and 17 may be recorded.
Okay,
your lordship.
then that's all, 16 and 17,
Lordship.
So then this is your tree gone, and then
Lordship, coming to the next authority, your lordship,
net, this is
passed by
for the
the
same,
Madras
for
High
the
Court.
same point,
Yes, your lordship.
okay.
Lordship,
The-
passed by Madras High Court, your lordship. National Insurance Corporation Limited versus AP Prasanta Venkatesh, your lordship.
Hmm.
Relevant para would be in page number.
The land council also they can rely upon the decision of the High Court of Judicature at Madras. In what is the case number?
Lordship, CRP.
In
lordship.
CRP within bracket PD number 3685 of 2007. And MP within bracket MD bracket close number 1 of 2007. Within bracket National Insurance Company Limited. Motor third party claim of office. What is National Insurance Company Limited versus
Versus AP Prasanna.
versus AP Prasanna Venkatesh.
Venkatesh.
and RM and other, and another stuff, Okay.
Lordship,
The-
page number 3, your
The
lordship.
relevant portion
Para 14 and 15, your lordship.
is, the relevant portion is reproduced here and below. Then you type para 14,
15, your lordship. 14 and 15.
15.
Your lordship, if I may be.
Kindly read 14.
Lordship, 14, your lordship.
Hmm.
The purpose of production of a disability certificate was not for assessment of the percentage of disability. The tribunal was not bound to accept that disability certificate as a gospel of truth, your lordship.
Hmm.
The next page, your lordship.
Hmm.
The disability certificate has to be proved like any other documents in the manner known to law. The burden of proof is always on the claimant to prove the disability. The action of proof required for proving disability certificate depends on the fact of a given case. In the case, the disability certificate was issued by the medical officer who had the benefit of treating the injured, your lordship. Such medical officer would be in a better position to tender evidence with reference to the injury sustained by the claimant, treatment given, action of permanent disability, as well as the loss of earning capacity. However, in cases where certificates were issued by the medical doctors other than the doctor who treated the injured, the evidence of such medical officer requires strict scrutiny. However, cannot be said that such certificates are inadmissible as in evidence. The evidence so tendered by the doctors who had no opportunity to treat the injured should be convincing and it should be based on accepted norms. It is only the standard of proof which would differ, your lordship.
So as per this also, I think the evidence tendered by the doctor who had no opportunity to do so
Yes, your lordship.
should be convincing and it should be based on accepted
Your
knowledge.
lordship.
Okay.
Your lordship, what has happened in the criminal MSC for your lordship? No medical doctors was examining, your lordship. As such, the OPD certificate, disability
So
certificate.
did you
was
raise
approved.
objection to the production of this medical document at the time of trial?
Your lordship. Lordship, in my written statement, your lordship. CD, case record, your lordship. My
Yes.
CD,
Yes. Yes.
appointments have not been met, your lordship. The appointments have not been met in the written statement, your lordship.
So you have not raised any objection
Yes, your
at the
lordship.
time of production of the said document?
Your lordship, this is just the written statement before the hearing, your lordship, before the examination.
In a written statement, have you made an aberrament?
Lordship, regarding the medical disability certificate, no, your lordship.
No. Then it was accepted only.
Lordship. No appointments have been made, your lordship, but oral submissions have been given, your lordship, at the time of the hearing, your lordship.
Whether the other witnesses were examined before the
Your
court?
lordship, no
Only on the
witnesses
basis of
were
the
examined.
affidavit?
No examination were examined, your lordship.
No examination?
Yes, your lordship. Nor the medical officers or medical professions, no
No,
one was examined.
That's it. No, what about the claimant? Claimant was examined in the court.
Yes, your lordship. Claimant.
He was cross-examined by you.
Your lordship, cross-examination, your lordship, case record is not here.
He was not cross-examined.
Your lordship, the claimant as well as the driver was cross-examined, your lordship.
Not cross-examined.
Cross-examined, your lordship.
Then you were given an opportunity to cross-examine.
Your lordship.
Okay, then how can you raise then now? You were given an opportunity, you did not avail. Now at the appellate stage, can you raise?
Lordship, the coercion of law, your lordship, can be raised at any stage, your lordship, which is the principle of your lordship.
Okay, then what is para 15?
Para 15, your lordship.
Okay.
When the burden was on the claimant to prove the percentage of disability, your lordship. The
Para
apprehension
para
raised by
15
the
also.
petitioner has no bias, your lordship, basis.
Okay, no bias. Okay,
No
no
basis,
basis,
your
no
lordship.
basis.
The counsel for the insurance company was entitled to cross-examine the expert with reference to the certificate issued by him bringing out the truth, your lordship. There are certain guidelines issued by the purpose of evaluation of permanent disability impairment in accordance with the decision of the expert group meeting on disability evaluation held in New Delhi during so-and-so, Your Lordship. Lordship, what has happened is that in the MAC appeal, Your Lordship, MSC case filed by the claimant, Your Lordship, no medical officers were examined, Your Lordship.
No, that is true.
Lordship. Lordship, as such, no opportunity was given to the
No, but then the claimant was examined
Your Lordship.
by the claimant,
Only the
claimant,
claimant,
from
Your
the
Lordship.
claimant side.
Yes, Your Lordship.
But then claimant only had produced this medical certificate also.
Yes, Your Lordship.
And then you were given an opportunity
Yes,
to
Your
cross-examine the claimant.
Yes, Your Lordship.
And then at the time of production of the medical examination certificate for this, the medical documents.
Yes, Your Lordship.
So we have not raised it. Otherwise, the
Your Lordship, during cross-examination.
cross in other,
During cross-examination, Your Lordship, this issue was been raised, Your Lordship. But it was not from the competent authority, Your Lordship, the OPT, Your Lordship,
okay.
the certificate, Your Lordship.
Okay, then the para 15 entire, you want to,
Your Lordship, till second line your sentence, Your Lordship. That's
Hmm.
correct, Your Lordship.
truth, up to truth.
Yes, Your Lordship.
Okay. 15 up to truth, I have marked, okay. Okay, then next,
Lordship, regarding the
that
next
is the ground 2.
one. Yes, ground,
Okay.
regarding the ground 2 entry, Your Lordship, a compilation of ground 2 entry, Your Lordship.
2 and 3.
Yes, Your Lordship. And Your Lordship, regarding disability certificate, Your Lordship,
So 3 is,
same ground, Your Lordship, ground B of the MAC appeal, Your Lordship. Ground
no,
A.
B, we have already stated.
Yes, Your Lordship.
So ground 2 is your K.
Yes, Your Lordship.
Ground K is your ground 2. And what is ground, which one is ground 3?
Ground 3 is also arising out of ground K, Your Lordship. Regarding, yes, Your Lordship,
Okay,
and similar citation, Your Lordship.
okay,
Your Lordship, if I may be allowed to,
5.
regarding disability certificate, Your Lordship. Claimants cannot rely on disability certificate, Your Lordship.
So disability certificate, admittedly, you see, it was
Yes, Your Lordship.
exhibited and you had you have not raised any objection
Yes, sir.
to the production. So here, para,
Lordship, some para, Your Lordship, para K, Your Lordship,
para, K.
Your Lordship.
No, here in the this one in the Supreme Court, this is Supreme Court.
Oh, Your Lordship. Your Lordship, this last serial number, Your Lordship, authority
Okay.
number 5, Your Lordship, it will be relevant to ground number 4, Your Lordship, the last ground, Your Lordship. The last ground, Your Lordship.
Para 5. What did you say? Being agreed by the.
Lordship, para, page number 6, serial number R, Your Lordship.
R.
Yes, Your Lordship.
No, serial number, there is no.
MSc, my make.
Oh,
Your
yes,
Lordship.
yes.
Coming to my make.
Your make appeal.
Yes, Your
R,
Lordship.
R is ground number 3.
Yeah, ground number 4, Your Lordship.
Ground number 4, okay.
Lordship.
But then the ground 3 is same only.
Yes, Your Lordship.
It is about the medical only.
Yes, Your
That
Lordship.
will
2
be
and
only
3, Your
ground,
Lordship.
that, 2 and 3.
Your Lordship. It can be compiled as 1, Your Lordship. Can be read as 1, Your Lordship.
So that is about the medical
Your
documents
Lordship.
only. That is ground 2.
Yes, Your Lordship.
K only.
Yes, Your Lordship.
Okay. Then
Yes.
this is
R, Your Lordship.
next is R.
Your Lordship.
Okay, next ground 3 is R. Okay, R.
Just on the ground that the.
That the line MSCT, Mokokchung Nagaland has failed to appreciate the fact of the case. So also failed to marshal evidence from proper perspective and has passed impure judgment and order dated 2019 without application of mind. This is just general only. Application of mind,
Just
as,
a general
as such, the same is liable to quash and set aside.
Just general ground, Your Lordship.
This is general ground only. So in this, you have a ruling.
Yes, Your Lordship.
Okay.
Para 11, your lordship.
In this regard, the learned counsel for the appellant has taken.
Lordship, this is somehow relevant to the ground 2 entry, your lordship, regarding.
Which one?
Regarding somehow relevant to ground 2 entry, your lordship.
This, your
The
fifth also,
citation authority, your lordship.
not to the 2 and 3.
Yes, your
Okay.
lordship.
But this is, we have read ground 4 only.
Yes, your lordship.
Why you are producing this in ground 4?
Lordship, this ground have been solely based on
Okay,
the
para-
compensation awarded to by the landed criminal to the claimant, your lordship.
Okay. This
Without
is
considering the validity of the permanent disability and as to whether the permanent disability.
the relevant portion in this
Para 11, your lordship.
citation, huh? Para?
Page number 11, your lordship. The last second para, your lordship. Page 11, last second para, your lordship. Lordship, this ground, if I may be, your lordship, is solely based.
In para 12.
Yeah, lordship, para 12, last para, your lordship, last para.
Huh?
Serial number 12.
Para 12.
Yes, your lordship.
Para 12, last para.
Yes, your lordship.
Okay, if the tribunal
Concludes that there is no permanent disability, there is no question of proceedings and determining the loss of future earning, your lordship. Lordship, coming to the last line, after the tribunal ascertains the actual permanent disability of the claimant based on medical evidence, it has to determine whether such disability has affected or it will affect his earning capacity, your lordship.
this is in ground 2 and 3.
No, your lordship, this is somehow relevant to ground 2 entry, but coming to the general ground, your lordship. it's
Okay,
ground number
okay.
4, your lordship.
Okay. The learned counsel is taken reliance upon the decision of the Supreme Court in civil appeal number 8598 dash 8599 of 2022. Within bracket, Talal Kena Gowda Parameswarappa versus the branch manager, New India Assurance Company Limited and others. Start. Relevant, para 12, I have marked, huh? If the tribunal concludes, little bit, not much, okay? After earning capacity, para 12, huh? Okay.
Lordship, what my
Okay.
submission is that in para 14 is that the tribunal has failed to ascertain.
Yeah,
as
in
to
the same citation.
Your lordship. Lordship, this is of the citation, your lordship. The learned tribunal has failed to consider the ability of the permanent disability, your lordship. And
Para
para 13, your lordship.
13.
Your lordship.
Reading from?
From the beginning, your lordship. Ascertainment of the effect of the permanent disability of the actual earning capacity involves 3 steps, your lordship. The tribunal has to first ascertain the activity the claimant could carry on.
Yeah,
on
where are you reading? Para
Para
13.
13, your lordship.
Okay.
Page 11.
Para 13, page 11
Serial number 5, your lordship.
of
The last flag is number 5, your lordship. TJ
okay, yes. Para 13. Okay, ascertainment.
Yes, ascertainment of the.
Also para 13. Huh?
Yes, your lordship.
Entire para 13.
Yes,
Can
your
you
lordship.
read?
Your lordship. Ascertainment of the effect of the permanent disability, your lordship, upon the earning capacity of the claimant, your lordship. Lordship, what has been recorded is that the tribunal has to first ascertain as to whether the claimant could carry on in spite of the permanent disability and what he could not do so as result of the disability, your lordship. Lordship, the tribunal, without taking into consideration the entire paragraph, your lordship.
Entire paragraph.
Lordship.
Okay.
Your lordship, the tribunal, without considering the disability of the claimant and as to whether the disability will affect his earning, your lordship, has passed the impugned judgment on order, your lordship.
After ruling, na?
Yes, your lordship.
After typing para 13. Then learned counsel for the claimant further submits that the learned tribunal has passed the impugn judgment,
Without
impugn
taking into
judgment and order
consideration.
without taking into consideration of
As to whether the permanent disability have disabled the claimant from or
as
affected
to whether the permanent disability,
permanent disability have disabled him or affected or will affect his earning capacity, Your Lordship.
the claimant has been affected by,
Whether the claimant has been affected by the disability,
okay, whether the claimant has been affected by the disability
yes, Lordship,
as claimed,
Your Lordship, affecting his earning capacity, Your Lordship,
disability affecting his earning capacity.
Your Lordship.
Okay. Stop. Okay.
Lordship, these are the just few grounds, Your Lordship. I'll be pressing on Your Lordship.
Much.
Lordship.
Then what is your prayer?
Lordship, my prayer is that the impugn judgment on the order, Your Lordship, passed by the tribunal be squashed and set aside, Your Lordship.
And for the above region, the entire judgment you want to,
Yes, Your Lordship, or a deduction be met on the.
for the region stated
award,
above, the land council for the claimant prays for setting aside and quashing of the impugn judgment and order passed by the land tribunal on 22/10/2019. Stop. That's all.
Yes, Lordship.
Okay.
that's-
Yes, respondent.
Lordship, may it please your lordship,
Yes, please.
I have prepared a small gist, may I forward on copy?
Please, yes. Hmm? Oh, gist of the petitioner. Okay.
May it please your lordship,
Yes, please.
lordship. As submitted by my learned friend, it is appeared that he has only two objections in the appeal.
Yes.
Number one is, according to him, that there is no rash and negligent driving. Number two is that there is no medical certificate to prove that he is the claimant is a disabled of 25%.
Yes.
That is the only two ground raised before your lordship now.
Yes, yes.
And means he has already abandoned the other issues, whatever ground raised before this honorable court. So my submission before your lordship will be limited only in these two grounds.
Okay.
Lordship. First of all, lordship, I will recite the fact of the case, lordship. On 28/4/17, while the respondent claimant was traveling from North Lakhimpur to Guwahati as an occupant of the vehicle number AS07J6066 Chevrolet Beat car, driven by owner cum driver, and at reaching near Gorsuk Borhat bypass about 4:30 AM, due to reckless, rash and negligent driving of the driver, lost control and collided with two guard posts of the roadside and rolled down from the main road. Resultantly, the respondent claimant sustained grievous injuries of fracture, lower third femur, head injuries and other blunt injuries on the entire body, and taken treatment at different places at BP Bimala Prasad Soliha Civil Hospital, Nagaon, thereafter at Dispur Private Hospital, and become permanently disabled of 25% as assessed by the competent medical board, and incurred huge amount of expenditures for his medical treatment. After completion of proceeding and being satisfied with the material evidence available before him, the learned member awarded total compensation of rupees 9,80,065 along with interest at the rate of 9% per annum from the day of filing of the claim, that is from 7/12/17 until payment in favor of the respondent claimant, and directed the appellant to deposit the awarded amount within a period of 30 days from the date of judgment. Lordship, the objection raised, actually, it has no legs to stand before your lordship. Lordship, I would like to refer the written statement of the appellant, what is filed before the court below, lordship. Lordship, the written statement of the appellant in para number 2.
Where do we find?
Yes, lordship, the written statement of the appellant in the LCR. And I have categorically mentioned in my gist in page number 2 even. Lordship.
Page number
2.
2.
Page number 2, the appellant filed, WS filed by the appellant before the learned member divided into 2.
Where are you reading? You are reading para?
In the page number 2,
Yes.
para number 3, Lordship.
Okay.
WS of appellant filed before the learned tribunal divided into some parts,
Yes.
such as preliminary objection and on merit, Lordship.
Hmm.
On merit, in para number 2 of the WS, the appellant simply denies the all affirmatives made in para 1, 2, 3, 4, 5, 6, and 8
Just
for want of knowledge and information.
yes, just a minute. Let me find out.
Yes, Lordship.
The
The copy of the WS is available in the LCR, Lordship.
yes, para.
Para, Lordship may find it on
Yes, yes,
merit
para 1, 2,
in page number 2 of their WS.
3.
On merit. Here in para number 2 on merit column, they have simply stated that 1, 2, 3, 4, 5, 6, and 8 of the written statement denied only for want of information, Lordship. Lordship, we will find again para number 3, Lordship. In para number 3 of the appellant, it is written that simply not admitted the correctness made in para 9, 10, 11, 12, 13, 14, 15, 16, 18, and 21, Lordship.
This is written statement on behalf of opposite number 1.
Opposite, no, Lordship, insurer appellant.
You are referring to the opposite number 1 only. You are referring to the written statement filed by the opposite party number 1.
No, Lordship 2.
Just a minute there.
In the court below, appellant is included as a respondent number 2.
Yes.
Lordship.
Yes.
Whatever objection, when the objections are not specifically raised before the court below, means amounts to admission of the entire claim now. This is a mere written statement of the appellant. Nothing has been specifically denied against the claim, Lordship. So it is amount to admission. When all the claims has been admitted in the written statement, how appellant can now raise this objection before your Lordship? Lordship, in my gist of argument, I have categorically referred my submission in page number 2, submission against ground number B and C, that is the allegation no rash and negligent driving of in the case, Lordship.
Yes.
Lordship. The allegation of no rash and negligent driving are incorrect and wrong. Whereas the appellant in their written statement in preliminary objection part in para 3 fairly admitted that is also interesting, Lordship. The insurer has no liability in respect of the present claim as the claimant was injured due to rash and negligent driving of the alleged vehicle in which he was one of the occupant. As such, insurer opposite party number 2, HDFC Ergo General Insurance Company is not liable for any compensation.
He himself submitted.
Lordship, it is already admitted.
Yes.
It is already admitted in the written statement even that accident took place because of the rash and negligent driving of the opposite party number 1. Because of that, their objection is that claimant is not entitled for any compensation.
So
it is a specific allegation.
No liability in respect of the present
Lordship.
Yes, claimant was injured due to rash and negligence. Okay, so admitted that there was
Yes, Lordship.
rash and negligence.
Rash and negligence is already admitted, Lordship.
Yes,
Only question is now whether claimant is entitled to the compensation or not.
yes,
Lordship. In my gist of argument, para 2,
yes.
the appellant, in contrary to their fair statement about the rash and negligent driving in para 3 of their written statement, now allege that respondent claimant failed to establish rash and negligent driving against the offending vehicle is contrary to their own statement. Lordship. To
Yeah.
prove the factum of rash and negligent driving, the learned member frame and issue number 1 to prove the allegation of rash and negligent driving, whereas the appellant did not find out any evidence to contrary to the prove their allegation, Lordship. In examination in chief of the respondent claimant as PW1 stated that on 28/4/17 boarded with the offending vehicle, I was proceeding to Gauhati from North Lakhimpur. At about 4:30 a.m. near Gorsuk Borghat bypass, the driver come owner of the vehicle lost control due to high speed and collided with 2 guard posts of the road and rolled down below the road. Resultantly, I have sustained grievous injuries of fracture, lower third hammer, head injury, and other blunt injury in the entire body. The accident dated 24/8/17 was the sole negligence of the owner cum driver of the offending vehicle who was driving the vehicle at the time of accident very fast and recklessly. Lordship. What is the cross-examination now? PW1, the owner who contested the case in the court below, in his cross-examination, he stated that to reply, the PW1 stated that it is correct to say that on the day the vehicle in which I was traveling turned total due to careless driving of the driver, namely Ajay Shankar Pandey. The statement of PW1 remain uncontroverted and unshaken. Rather,
This is stated by
it is stated by PW1 claimant.
PW1.
Yes, in his cross-examination by the vehicle owner.
So it is correct to say that he admitted that.
It is correct to say that, Lordship, on the
I was traveling turtled
yes, Lordship,
due to careless driving of the driver
come owner
of the
actually.
vehicle where he was a passenger.
Claimant was the passenger, occupants
Okay.
of the private car.
Okay.
Yes, Lordship.
Yes.
Vehicle was driven by the owner, Ajay Shankar Pandey. That is the cross-examination. Again, the statement of the PW1 remain uncontroverted.
Whether in this, just a minute, pause for a moment. Whether this Ajay Shankar Pandey was also injured.
He is also injured minor.
He also filed.
He is minor injured.
He was also granted. He was also awarded any.
No, he has not
He did
filed
not
any
file.
claim because being he is the owner come driver of the claim.
Okay, he did not.
He cannot go.
He cannot.
He cannot.
Okay. Yes. Oh. I think we can resume it too.
Lordship. Lower court evidence.
DIG আহে কাৰণে অলপ কথা কৈ আছে নিশ্চয়। DGP আহে কাৰণে না। 3 জন।
Sorry for the delay.
May I continue, Lordship?
Yes, please.
Please, Your Lordship. In my gist, not the last paragraph,
Yes,
page number 3.
yes,
The learned tribunal, based on the available evidence, rightly held that the accident dated 28/4/17 was the result of rash and negligent driving of the owner cum driver of the offending vehicle. Despite the fact, the respondent claimant respectfully submits that MSC case is a summary civil proceeding wherein the claimant is not required to prove the case as if like other civil and criminal cases. For satisfaction of this honorable court, the respondent claimant relied upon the following decision of our apex court. Lordship, in NK He Bose Private Limited versus N Karumai Amul and others, reported in Supreme Court jurisprudence in motor accident claim cases, page 161. Or otherwise, it is referred in AIR 1980 SC 1345. In para 3 and 4, Lordship, in para 3, fourth line. In para 3, fourth line, Lordship.
yes,
Wherein the Honorable Supreme Court held that Accident Claims Tribunal must take a special care to see that innocent victims do not suffer and driver and owner do not escape liability merely because of some doubts here or some obscurity there. Save in plain case, culpability must be inferred from the circumstances where it is fairly reasonable. The court should not succumb to niceties, technicalities, and myetics, maybe. Lordship, I would like to refer another decision in Zanbai, widow of Dinkaro Ghorapade and others versus ICICI Lombard Insurance Company Limited, reported in 2022 10 SCC page 512, Lordship. The relevant para is 11. Wherein the Honorable
Just a
Supreme
minute,
Court
just a minute.
held that we find that
just
the,
a minute.
yeah, Lordship.
Hmm.
Para 11, Lordship.
So just a minute, here you have mentioned in para 3 and 4.
That is Supreme Court in jurisprudence in Motor Vehicle Act, Lordship.
So just a minute, 3 and 4, and para 4 you have not read.
In fourth line, Lordship, para 3, fourth line.
Oh, this is, okay, fourth line.
Yes, fourth line,
Sorry.
Lordship.
Hmm.
Para 3, fourth line, Lordship.
Okay.
Yes, Lordship. My second submission before your Lordship is reported in 2022 10 SCC 512.
Okay.
Para 11, Lordship. Wherein the Honorable Supreme Court held that we find that the rule of evidence to prove charges in criminal trial cannot be used while deciding an application under section 166 of the Motor Vehicle Act 1988, which is summary in nature. There is no reason or doubting the veracity of the claimant statement of the appellant number 1 who suffered injuries in the accident. The application under the Act has to be decided on the basis of evidence laid before it and not on the basis of evidence which should have been or could have been laid in a criminal trial. We find that entire approach of the High Court is clearly not sustainable. Lordship, in Union of India versus Saraswati Devnath and others, 1995 2 GLT, page 117, the relevant para is 6.
Yes.
Wherein our Honorable Court held, the law is settled that in a claim under Motor Vehicle Act, the evidence should not be scrutinized as a manner as is done in a civil suit or a criminal case. In a civil case, the rule is preponderance of probability, and in a criminal case, the rule is proof beyond reasonable doubt. It is not necessity to consider these necessities in a matter of accident claim case in as such as it is a summary inquiry. If there is some evidence to arrive at the findings that itself is sufficient, no necessity, doubt, or suspicion should wait with the tribunal in deciding a motor accident claim case, Lordship. Lordship, in Bimla Devi versus Himachal Road Transport Corporation and others, AIR 2009, Supreme Court 2819, said also reported in 2009, 13 SCC 530 in para 13 and 16, para 13 to 16, Lordship.
Yes.
In para 15, Honorable Court held it is necessary to be borne in mind that strict proof of an accident case by a particular bus in a particular manner may not be possible to be done by the claimant. The claimant were merely to establish their case on the touchstone of preponderance of probability. The standard of proof beyond reasonable doubt could not have been applied. Lordship, in Kusumlata and others versus Sadbir and others, 2011, 3 SCC 646 para 9. It is well known that in a case relating to motor accident claims, the claimants are not required to prove the case as it is required to be done in a criminal trial. The court must keep this distinction in mind. Lordship, wherefrom it is clearly appeared that from the evidence, unshaken evidence of the claimant and cross-examination of the appellant, it is appeared that there is no dispute at all in regards to the rash and negligent driving of the offending vehicle who caused the accident. Even the claimant involved in the accident and injury sustained thereby. Lordship, since my learned friend has already abandoned the other ground, only except two ground, rash and negligent driving and medical evidence. Lordship, my written gist in page number 8, Lordship. Page number 8, Lordship.
Yes.
Lordship. The allegation is that no doctor examined, Lordship. Lordship, in absence of dispute in regard to the injury and disablement of the respondent claimant, non-examination of doctor cannot be fatal while deciding the MSC case. Lordship, there in the court below, there is no dispute at all in regards to the disablement of the and non-examination of the doctor. So how that can be raised before your Lordship now?
Just tell me, the
Lordship.
evidence was filed in affidavit or it was?
Evidence was filed in deposition on affidavit. Thereafter, it has been cross-examined by the appellant.
Okay.
Yes, Lordship.
Okay.
Lordship, in para 2, in examination in chief of the claimant stated that resultantly, I have sustained grievous injuries of fracture, lower third hammer lip, head injury, and other blunt injuries on the entire body. I was admitted for initial treatment at BP's Civil Hospital, Nogao. Thereafter, shifted me to Dispur Hospital Private Limited on the same day, wherefrom discharged on 3/5/17. Now, it is interesting, Lordship. As directed by the Honorable Tribunal, I was re-examined by the Medical Board of Imkong Liba Memorial Civil Hospital, Mukopsang, who thoroughly examined me and categorized my present disability at 20 as incurable at 25%. The disablement certificate, as I have received, is marked and exhibit as P13, Lordship.
This 13 is a certificate or this is only just?
No, this is the exhibit 13, Lordship, because the claimant was treated at different places.
Yes.
As such, to know the present disability of the claimant, the learned tribunal has requested the Mukoksang Civil Hospital to examine through a board.
Okay, it was on the direction of
Yes, on the direction of the court, Lordship.
So on which date? 3/5.
That is the lordship, the medical disablement certificate is exhibit 13.
No, that is there, but then where is the direction of the members of tribunal? Where do we find? Because it is
Yes, lordship.
the
Yes, lordship.
direct counsel for the appellant challenged this, that it has got no validity. And if it was on the direction of the hospital, sorry, the tribunal,
Yes, lordship.
when
because
it was directed.
I have prayed, the claimant has prayed to the learned tribunal since he has taken.
On which date? On which date? Is it available in LCR?
Yes, in the LCR lordship.
On which date? This P13 was issued on when?
Yes, lordship. Order dated 8/8/18. 8/8/18 lordship, LCRs. Lordship, may I read, lordship?
Yes, please.
Yeah. Counsels present. Counsel for the claimant prayed that the claimant has taken treatment in different places as such to determine the present disability of the claimant may be directed to appear before the medical board of the district Bukokchung. Heard the counsel and prayer aloud. Directed the claimant to appear before the medical board and produce the certificate. That was the order of the learned tribunal lordship. So, as directed by this honorable court,
Just a minute.
tribunal,
So this order,
yes, lordship.
based on this order, any forwarding was done? Or
That-
any forwarding
No,
letter?
lordship, that has been actually forwarded to the civil hospital
Not
by the
yet.
tribunal himself,
Not made available to the claimant.
not been available with the claimant lordship. That was the, they have sent it officially lordship.
Okay.
Yes, lordship. On the basis of the request of the tribunal, the respondent claimant was examined by constituting a medical board who categorized the disability of the claimant at 25% uncurable present permanent disability. That is the exhibit P13 lordship.
Yes.
Exhibit P13 lordship. Lordship, the respondent claimant, while cross-examined by the appellant insurer, the statement of the claimant remain unshaken. Even not a single point could able to find out that the respondent claimant was not sustained grievous injuries and thereby become permanently disabled as assessed by the medical board. Rather, reaffirmed that it is correct to say that due to the accident, I have seriously injured. As such, I have undergone many operations in different hospitals and I have spent near about 5 lakhs for my teeth. Further, to reply the cross-examination of the opposite party number 1, the respondent claimant categorically stated that it is correct to say that I am permanently disabled. From examination and cross-examination of the claimant, it is made clear that there is no dispute of the appellant as well as the other opposite party in regards to the disability of the claimant. The respondent claimant marked and exhibited the medical disablement certificate issued by the medical board as exhibit P13, which appeared to be marked and exhibited on consent without any objection. There is no objection at all, lordship, before the court below in regards to the medical certificate. Lordship, for satisfaction of this honorable court, the respondent claimant relied upon the following decision of the Honorable Supreme Court as well as of our apex court, lordship. My learned friend has cited one decision before your lordship, 2011 1 SCC 343. So he has not actually, he skipped to cited the para 23. Where is the total findings of the Honorable Supreme Court? Lordship, in the said judgment, Rajkumar versus Ajoy Kumar and another 2011 1 SCC para page 340 para 23.
Rajkumar,
Page 340
just a
para
minute,
23.
just a minute.
Lordship.
Party name, Rajkumar. Para?
Para 23, Lordship. The Honorable Supreme Court regards to.
Just a minute.
Yes,
Para
Lordship.
23, have you quoted here?
Yes, Lordship. Yes, Lordship.
Okay, you have quoted 20. Para 23.
Lordship.
And then just a minute, and then the learned counsel for the appellant quoted with para.
From the said judgment, the appellant has referred some para before your Lordship, but the appellant failed to submit before your Lordship. What is the total
He
findings
has
of the
quoted
para 23
16
of the
and
Honorable
para
Supreme?
16 and 17.
Yes, Lordship. Whereas in para 23, that this is the total findings of the Honorable Supreme Court in regards to examination of doctor and others, Lordship. May I read it, Lordship?
Para, yes.
Para 23, Lordship.
Yes.
The Honorable High Court in regards to examination of doctor recognizing their valuable time give 4 suggestions. Firstly, effort should be made to record the evidence of the treating doctor on commission after ascertaining their convenient timing. Secondly, if the doctor attend the tribunal for giving evidence, their evidence may be recorded without delay, ensuring that they are not required to wait. Thirdly, the doctor may be given specific time for attending the tribunal for giving evidence instead of requiring them to come at 10:30 a.m. or 11 a.m. and wait in the court hall. Fourthly, this is the very interesting, Lordship. Fourthly, in case where the certificate are not contested by the respondents, they may be marked by consent and thereby dispensing with the oral evidence, Lordship. These small measures as also may any other suitable steps taken to ensure the availability of the expert evidence will ensure assessment of just compensation and will go a long way in demonstrating that courts, tribunal should concern for litigant and witnesses, Lordship. Lordship, in the court below, the medical certificate filed and marked and exhibited, there is no dispute at all. Not a single question even raised about his disablement.
Yes.
So means the medical certificate is exhibited on consent.
Yes, yes.
Lordship.
There was no cross in this regard.
Yes, Lordship.
Yes.
In Oriental Insurance Company Limited versus A.J. Thomas 2010 1 TSE 414 Gauhati in para 11 and 12, Lordship. In appeal, question the finding of the learned tribunal on the permanent disability to the extent of 40% without taking any evidence of the doctor and awarding the compensation. In this regard, it is to be noted that the respondent claimant produced necessary medical certificate before the tribunal, learned tribunal, and the appellant had opportunity to pursue the same. No doubt the respondent claimant did not examine the concerned doctor, but the appellant at no point of time made any prayer before the learned tribunal to summon the doctor concerned for examination to testify the veracity of the medical report, and thus it failed to avail the chance of calling the material witnesses. Accordingly, the appeal of the insurer dismissed, Lordship. Lordship, the another decision, United India Insurance Company Limited versus BL Jachunga and others 2008 3 GLT page 931, Lordship. The relevant para 6 in page number 934. The last paragraph number 6, Lordship.
Yes.
This certificate is supposed to be The
Last paragraph.
certificate is supposed to be by the hospital, documents number.
Just a minute,
exhibit.
where are you reading? Just a minute, which para?
The last paragraph, end of the para 6, Lordship.
End of the para?
Para 6, Lordship. The relevant page number is 934. Last part of para 6, Lordship. Wherein held that this certificate is supported by the hospital documents Exhibit C9, Exhibit C91, Exhibit C92, and Exhibit C12 mentioned above, and there is nothing to doubt about the genuineness or authenticity. In fact, during the trial, the appellant opposite party did not raise any question on the genuineness of the certificate, Lordship. Lordship, our decision of our own court
In MSC Appeal 118.
Yes, Lordship.
Yes.
National Insurance Company Limited versus Deepmani Sharma and others. Wherein in para 6, our honorable, the relevant page number 7, Lordship.
Just a minute.
Para 6, Lordship, relevant page number 7.
Yes.
Of the judgment. Wherein honorable court dismissed the appeal finding no merit. And in MSC appeal number 20 of 18, in para 7, Lordship.
In the same.
In the another judgment, that is Solamandalam GS NIC Insurance Company versus Vicky Hussain and others. Para 7, Lordship.
Okay.
Wherein also this honorable court held there is no merit of the appeal accordingly dismissed. In both the appeal, honorable court pleased to hold that objection which has not been raised in the court below said cannot be a ground for appeal. Accordingly, both the appeal filed by the appellant insurer dismissed.
Yes.
So this is the only two ground my learned friend has raised before this honorable court.
Yes.
And this is my submissions before this honorable court. And whatever ground set forth raised before this honorable court, there is no leg to stand before your lordship, because such objections are not raised court below. No contrary evidence to the contrary could able to produce before the court below. And as such, the appeal is liable to be dismissed with compensatory cost as the insurance company by filing the appeal, putting inconvenience to the road victim's person. This is my submission, Lordship.
Okay.
If I may, Your Lordship.
Yes.
Lordship, regarding to the objection raised by the learned counsel, Your Lordship, regarding non-contesting of the rash and negligent driving, Your Lordship. If Your Lordship would come to the written statement filed by the opposite party number 2, Your Lordship, the insurer party, Your Lordship.
Before the tribunal?
Yes, Your Lordship.
Opposite party number 2, yes.
Yes, Your Lordship. Written statement, Your Lordship. Paragraph number 6, Your Lordship. So on merits, paragraph number 3.
Yes.
That the answer, if I may, Your Lordship.
Yes.
The answering opposite party denies the claim under Section 116 of the NV Act of 1988 is maintainable in law against the opposite party in present form. The accident did not occur due to the rash and negligent driving of the vehicle insured by the present answering authority, Lordship. Lordship, here it is clearly mentioned, Your Lordship, here in the written statement that Your Lordship has that the insurance party, Your Lordship, that they have contested regarding the rash and negligent driving, Your Lordship.
So this is
written statement, Your Lordship, file
opposite party number 2 is
the insurance, the appellant. Your
Insurance.
Lordship. Yes,
This is what you are submitting.
Your Lordship.
Yes.
Yes, submission is clear to Your
Mm.
Lordship. They have the insurer in the written statement, Your Lordship, they have
Okay.
submitted that the accident did not occur due to the rash and negligent driving of the vehicle insured by the present and answering party, Your Lordship.
Okay.
Your Lordship, and regarding Your Lordship, coming to the OTB ticket, the disability certificate, Your Lordship. Its order, it was issued on 7/5/2019, Your Lordship. And the written statement filed by the insurance company was on 2018, Your Lordship, prior to that year, Your Lordship. The written statement was filed on 2018, Your Lordship. April 2018, Your Lordship.
Written statement was 2018.
Yes, Your Lordship, and the OPT ticket was obtained on 7/5/2019, Your Lordship.
No, after this only probably
Yes,
you
Your
were
Lordship,
given an
after written statement,
opportunity
Your Lordship.
for cross-examination.
Yes, Your Lordship.
So that is what he is
Yes, Your
submitting.
oral submission has not been recorded regarding the cross-examination. Your
Hmm. No, admittedly, but
Yes,
during cross-examination, you did not ask about
Yes.
about this medical document.
Yes, Your Lordship.
Okay.
Your Lordship, regarding coming to the relation accident driving, Your Lordship, that it was not contested in the tribunal, Your Lordship, is,
Okay.
it was
So,
contested, Your
you
Lordship.
have made some averment.
Yes, Your Lordship.
Yes, okay,
Already been considered, Your Lordship.
yes.
Lordship, that's all, Your Lordship. Myself.
So we'll record the submission of the respondent, huh? Your first point is, just a minute, huh? We'll just record your submission, lest I forget. Hmm. Regarding your 25% disability, where it starts?
Lordship, in page
Submission in
number,
connection with
page number 8 of my gist.
8.
8, page number 8.
So this is second point, sorry. Yeah?
Yes, the second
And the
point.
first point is,
According to the appellant, it is a second ground.
okay, and the first ground,
First ground is Lordship in page number 2 of my gist. In the last paragraph,
last paragraph,
Lordship.
no rush in there, okay.
Lordship.
Mhm. The Adani Council for the respondent submits that the allegation of no rash and negligent driving are incorrect and wrong. Whereas the appellant in their written statement in the preliminary objection part in para 3 fairly admitted that the insurer has no liability in respect of the present claim, as claimant was injured due to rash and negligent driving of alleged vehicle in which he was one of the occupant. As such, comma, the insurer opposite party number 2, HDFC ERGO, General Insurance Company Limited, is not liable for any compensation. Stop, para. The appellant in contrary to their fair statement about the rash and negligent driving in para 3 of their written statement, now alleged that the respondent claimant failed to establish rash and negligent driving against the offending vehicle is contrary to the own statement. Stop. The land counsel for the respondent further submits that in order to prove the factum of rash and negligent driving, the land member MSCT framed an issue as issue number 1 to frame an issue as issue number 1 to prove the allegation of rash and negligent driving. Stop. Whereas the appellant did nothing to find out any evidence to the contrary to prove their allegation. Stop. You also want this also to be recorded in examination in chief?
Yes, Lordship.
Okay, so
Yes, Lordship.
he further submits that in examination in chief of the respondent claimant as PW1 stated that within inverted comma. So this you have to record. Okay, sir. On 28/4/2017, boarded with the offending vehicle, I was proceeding to Gauhati from North Lakhimpur. Stop. At about 4:30 a.m. near Gold Chowk, Borghat bypass, the driver owner of the vehicle lost control due to high speed and collided with two guard posts of the road and rolled down below the road. Resultantly, I have sustained grievous injuries of fracture lower third humerus within bracket L, bracket close, left, head injury and other blunt injuries in the entire body, inverted comma close. Stop. Stop. Then next again within inverted comma, the accident dated 24/8/17 was the sole negligence of the owner cum driver of the offending vehicle who was driving the vehicle at the time of accident very fast and recklessly, inverted comma close. Stop. Stop. Para. The Thane counsel for the respondent claimant, claimant further submits that the PW1 claimant was cross-examined by the insurer with the insurer appellant. Insurer appellant. Stop. And reply to reply to PW1, what is this?
Respondent claimant. He replied in the cross-examination, respondent claimant replied to the answer to the insurer.
Okay. The PW1 in his reply stated that within inverted comma, it is correct to say that on the said day, the vehicle in which I was traveling turned turtle due to careless driving of the driver, namely Ajay Shankar Pandey. Inverted comma close. Stop. It is submitted that the deposition of the PW1. So the statement of the PW1 remain uncontroverted and unshaken. Rather, it was reaffirmed that the rash and negligence driving of the driver for causing it was the rash and negligent driving of the driver for causing the said accident. Stop. And in contrary, no evidence could able to produce by the appellant in the before the tribunal. Stop. And what else is your submission in this point?
Lordship, I have referred some decision of the Honorable.
The decision which you have.
Yes, Lordship.
Okay. To support his stand, the learned counsel for the respondent has relied upon the decision of the Supreme Court. This is what cases? Supreme Court jurisprudence. Decision, huh?
Yes, Lordship.
In decision in NKV Bros. So I'll mark it, huh? Page 4. Page 4. Okay, so this entire. And then next also you want to refer?
Yes, Lordship.
Okay, next
These
also.
are all very relevant cases, Lordship.
4 cases.
4 cases, Lordship.
Okay, all 4 cases, huh? Page 4.
Total 5 cases, Lordship. In the next page.
5.
Yes, Lordship.
Okay, next page also 5. Okay. So that's all on that point.
In regards to the rash and negligent driving.
Okay.
In what way
That-
summary proceeding will be disposed of by this Honorable Court?
Okay. Para, huh? And next point is in regards to with regards to the allegation of no doctor has been examined, comma, the learned counsel for the respondent submits that in absence of dispute in regards to the injury and disablement of the respondent, claimant non-examination of doctor cannot be fatal while deciding the MSc cases. Stop. He further submits that in examination of chief, comma, the claimant stated that this is under inverted comma. I'll mark it. Okay. This is page 8. Page 8 I have marked, huh? Up to exhibit 13, huh? Is exhibit 13. Thereafter, the learned counsel for the respondent further submits that the above exhibit 13 was, sorry, just a minute, huh? The respondent, claimant was examined by the board of expert in Dr. Kongliba Memorial District Hospital, Mokokchung, Nagaland.
Mokokchung, Nagaland, Lordship.
Mokokchung, Nagaland, on the direction of the tribunal on 8/8/2018, wherein Eight is 2018. Just a minute, And the said direction was given by the Honorable, by the learned tribunal in presence of the learned counsel for both the parties. Okay, stop. Para. So next paragraph is not required. Is it required? Yes, learned counsel. Next paragraph. After this 13. Whether the next.
My submission, Lordship, may be the page number 9, para 1.
So this next paragraph, page 8.
Yes, Lordship.
No, I think that is enough. That was enough.
That was enough, Lordship.
Okay, and then page 9, para.
Page 9, para 1, Lordship.
The learned counsel for the respondent for the submits that from the examination of and cross-examination of the claimant, it is clear that there was no dispute of the appellant from the appellant side. There was no dispute from the appellant side as well as of the other opposite parties in regards to the disability of the claimant. Stop. And then what is
Lordship, that medical certificate issued by the board is mark and exhibit on consent.
Already marked here.
Lordship, it is mark and exhibit on consent, since there is no objection of the other.
The disablement certificate as I have received is marked and so, mark, it is there only.
Yes, Lordship, mark and exhibit on consent.
It is already there in the earlier paragraph.
Yes, Lordship.
Then what more?
Lordship, I have referred some decision of
The learned
Honorable
counsel for
Court.
the learned counsel for the respondent has taken a reliance upon the decision of the following decision of the Honorable. This is not court, Number 1, 1 in Raj Kumar versus Ajay Kumar and another. This which one you want to refer?
Entire assessment, Lordship. These are all relevant.
Okay, page 9, page 9. I marked, Page 9, 1, 2, 3, 3, and then this to 4, Where? And what is this?
Even there are two unreported cases I have cited before your Lordship, wherein the Honorable, dishonorable.
This not because that is sufficient, I think.
That is also enough, Lordship.
Okay, that is sufficient. Okay, that will be sufficient. And what more? That is your.
This is my submission, Lordship.
Okay.
Because there is only two ground, other ground of appeal may be skipped. And my submission is compensatory cost may be granted. Because by filing this appeal unnecessarily, the appellant putting inconvenience to the
appeal filed by the
victims.
insurer has no merit in the eye of law, and as such is liable to be dismissed with cost.
Lordship.
Okay, so this rest I'll dictate. And then it will be kept as the CA, yeah. Result, in the order. this kindly, appellant citation, okay? Both the learned counsel for the appellant, Mr. So as well as Mr.
B. N. Sharma.
B. N. Sharma, learned counsel for the
Respondent claimant.
respondent. Stuff, huh? Hearing completed. Judgment reserved. Okay. Okay.
Item number 28.
Next, Lordship.
Yes.
Lordship, but this is an appeal. While under 133 of the MSC Act. Against the giving the order 10-10-19. Passed by the Motor Accident Claim Tribunal Motor.
It's HCR. Okay.
In MSC case 44 of 2017. Lordship here, the petitioner, the my apologies, the appellant.
You are this you
insurance
are for
company. The appellant,
appellant. Who is the appellant?
the insurance company,
Insurance company,
New India Insurance Corporation Limited.
New India.
The claimant here is has filed a claim petition before the
Just a
MSC
minute,
to
let us ensure, just a minute, huh? Let us ensure. How many respondents are there?
What's the 3 respondents?
3 respondents. Who appeared for the respondent?
I'm appearing for the respondent claimant number 1.
You are for respondent number 1.
Yes, Lordship.
And who is for the respondent number 2 and 3?
Lordship, by order dated 14/8/2023.
Okay.
14/8/2023, Lordship.
Yes.
Lordship, the service upon the respondent 2 and 3 deemed to be completed. As the publication was made in respect of respondent 2 and 3, and affidavit have been filed. And this is in compliance with the order dated 5/6/2023, Lordship. Publication is made and affidavit has been filed. So the service upon respondent 2 and 3 is are deemed to be complete. Respondent 2 and 3 are the owner of the vehicle and the driver of the vehicle.
You have taken step upon them by a publication.
Lordship.
Okay, deemed to complete. So whether, as per the award, whether any direction is give, any direction against these 2 and 3? Who is to pay? Who is to pay?
Was against the appellant.
appellant.
Against the appellant 1.
Appellant.
Yes.
Appellant only.
Yes.
Okay. Okay, that's fine. Now, yes, what is your case
Lordship,
now?
the respondent 1, the claimant before the MCT as a filed in MSC case number 44/17, bring for compensation on account of injury.
This
of
is of
60%.
injury.
Injury, Lord, 60% disabled.
So award was on 10/10/19.
10/10/19, Lord. And the MSCT has awarded an amount of rupees 12 lakhs.
Just a brief of the case. No, let us start with the brief of the case.
Yes.
Because I have not gone through this. So how it started? You have annexed
Lordship,
you
here
can see the
the
brief of the in the Claim,
The vehicle in question,
hmm,
truck bearing registration number so and so met an accident on the way at Duhugari.
just a minute, we are reading, from the award. In the award, whether the short, brief story has been given.
Launched an ambulance.
Hmm?
Yes, Lord.
Yes, page come to page 30 and let us read.
So the brief take of the claimant is that on 19/8/17, under course of employment, while the claimant was traveling on the vehicle so and so from Gauhati to Tezpur on the way to Bihaguri, due to rash and negligent driving of the driver of the attending vehicle, the vehicle fell down the deep trench, resulting in the claimant sustained grievous injury and became permanently disabled. Having been sustained injuries, the claimant
Permanently disabled, okay.
permanently disabled. That is 60%. As per the judgment, is 60% disablement. That's
Okay,
what the claimant has.
Hmm.
The claimant
Okay.
has a Lordship, in the course of the case before the tribunal, 5 issues were taken up, and accordingly, the learned MCT Maustung has passed the decision and reasons accordingly, Lordship. And MCT Dimapur has directed the insurance company, this is the respondent three, here the appellant, to pay a sum of rupees 12,56,000.
the total award is,
12,56,000.
yes, 12,56,000.
Along with 9% per annum from the day of filing of the claim petition.
Okay,
That is from 7/12/17 until the payment within the period of 10 days from the date of this order, jointly and severally. Lordship may come to page 5 of my petition, Lordship.
yes,
Lordship, grounds, Lordship.
Hmm.
Ground B.
yes.
Ground B. For that, the learned tribunal has prima facie committed error and illegality in passing the final award without
Just a minute,
taking-
this is.
It's page 5,
and
ground B.
Okay. Just a minute, Let me see. Ground B.
Ground B. Maybe allowed to lead, Lordship.
Yes,
For that, the learned tribunal has prima facie committed error and illegality in passing the final award without taking into consideration the basic requirement of Motor Vehicle Act 1988 is prescribed under 166, section 166 and the Act pertaining to the fault liability.
okay, what is the basic requirement is according to you?
Lordship, here, the
Do we have the MS? Motor Vehicle Act, okay.
I may be allowed to read the section, Lordship. An application,
Just a minute,
Lordship,
yes,
166, section 160 of the NDI.
$166.
Lordship. Application for compensation.
Yes,
Lordship, I may be allowed to read section 166, application for compensation. An application for compensation arising out of an accident of nature specified in section 1 of the subsection 1 of the section 165 may be made by the person who has sustained the injury or by the owner of the property or where that
now,
is resulted from the accident.
according to you, so you said that the requirement, so it was without taking into consideration the basic requirement. What is the basic requirement which was not taken into consideration? Because this is general, this is general.
Yes.
Your ground is general. So what is the,
By A, 16A, it says that by the person who has sustained the injury. Lordship here, the injury, the injured person that's a claimant has not put forward the certificate.
okay, so.
The certificate was
That is separate,
used.
I think that is separate point.
Yes, Lordship.
Where, ground?
That is at the
Let us leave the
F,
general ground.
F.
F, no?
Yes.
We'll come directly to F without, leave the
Yes,
B,
yes.
no? So because this is general, so let us come to specific F.
F. Ordered the learned member, motor vehicle accident claim.
F or H?
F.
F, okay.
For that, the learned member, motor accident claim tribunal, motion has failed to take into consideration that the claimant has not submitted the disability certificate to establish 60% disability. As such, the award suffers miscarriage of justice and is liable to set aside.
For that, the question has failed to take into consideration that the claimant has not submitted the disability certificate. So they have not submitted disability certificate.
Lordship.
So on what basis they then claim that there was a 60% disability?
On their statement made in their claim petition.
Only on the basis of the statement made by the claimant?
Lordship.
No certificate,
No,
no
Lordship.
medical document.
No, Lordship.
So let us see the award where it is, where it says that 60%.
At page 16.
Yes.
Lordship may, just about the figures written in.
Okay, rupees so and so into 60%. No,
Yes, Lordship, that's the
one.
figures as well as the last paragraph at paragraph. Just about the figures, serial number 1. As opined by the medical board.
Page 16. Yes, as
Page
opined by the medical board.
The present disability of this claimant is 6% permanent in nature. To dissolve the income. To disprove the income and disability of the claimant, no evidence to the contrary would be produced by the opposite parties.
Just a minute.
Yes.
As opined by the medical board, the present disability of the claimant is 60%
Permanent in nature.
permanent nature. To disprove the income.
And disability of the claimant, no evidence to the contrary could be produced by the opposite party. Lordship, here the onus lies with the claimant to prove the injury, one, and to prove the income.
So no certificate was produced.
No certificate.
So let us see the LCR in their application, what they have, how they have mentioned.
Lordship.
Claim petition. So. Just a minute. Claim petition. The claim petition. Yes, 166. Do you have a written submission?
No, Lord.
Have you prepared? No.
No, Lord.
Okay.
Or the submitting verbally, Lord.
Apart from the submission to be made here in your term,
Lordship.
can you just, can we just directly come whether you have produced a certificate?
Yes, Lordship, exhibit P13, this is the medical
Okay, it
certificate
was
issued by a
certificate
board.
submitted.
Yes, it is there,
Okay.
Lordship.
No, there is.
Probably it is a oversight of my friend.
Okay. So because unless there is a certificate,
Yes, Lordship.
it was.
It is marked and exhibited as P13, Lordship.
Right.
He is also examined under order of the court tribunal.
This was also.
Yes, Lordship.
Exam, okay. Can we just see the certificate? It is annexure, sorry.
Exhibit P13, Lordship.
P13. So it is in there. 9/6.
That certificate is annexed with my deposition in affidavit in the court below in page number 122, Lordship.
Page number 1. So else, let us.
Deposition in affidavit of the claimant, page number 122.
This is application. Deposition. Okay. Yeah, okay. No? Is deposition available there? It will be there only. Deposition, where is, that's it. Deposition is there. Yes. There. No. Okay, there was a police report also here. There was FIR also was here in this case. FIR was.
Yes, Lordship, everything is there.
It was registered. Was it registered? FIR. What did you say? Exhibit? The certificate is exhibit?
Medical certificate is exhibit P13, Lordship.
Or 13?
Yes, Lordship.
9. 10. 11. Do you have the copy? What page it is marked?
Page number 122, deposition in affidavit of the claimant.
$122.
Yes, Lordship.
122 is something. Yeah, no, something else. Exhibit, okay, we have reached up to, it is exhibit 13.
Exhibit 13, Lordship.
Okay. Medical document. No, documents.
May I assist your Lordship?
Just a minute, huh? We have just crossed 12.
Yeah.
Exhibit 12. I think in some other documents. Because this is very important. Unless there is a certificate, you have a case. If there is no certificate. But then if there is a certificate, is available.
Yes, Lordship.
Okay. Oh, pagination different. That is why.
122 page long.
Oh, it is same like the one which we have seen earlier. One 59. Okay. So, but then you see, if there is a certificate, there is a certificate issued by the board. Yes.
My second ground is
Just a minute, huh?
it's for Lordship to decide
Hmm.
after examining the documents
Your-
on record.
The first ground is F, no?
F, Lordship.
Okay, yes, next.
Next is D.
B,
D.
D. Then second ground is D.
D, Lordship.
Okay, what
D
is this?
That,
Hmm.
I cannot read, Lordship.
Then,
For that, the learned tribunal,
you-
without application of
just a minute,
proper. by-
ground, huh? Hmm. The land council, the appellant file this MSC appeal on, among others, on the following grounds. Stop, huh? Then you'll see one, huh? That the learned member accident claim tribunal, Mokok Chung, has failed to take into consideration the claimant has not submitted the disability certificate to establish 60% disability, as such, the award suffers from miscarriage of justice and is liable to be set aside. Okay, and then number two ground would be that the tribunal, that the learned tribunal, without application of proper judicial mind, what this is general, the income, okay.
Lordship, the ground two is that Lordship, the claimant, he has submitted a certificate stating that he is earning rupees 6,000 per month.
Okay.
But Lordship, the learned tribunal below has enhanced the income of the claimant from 6,000 to 9,000.
Okay. So that is interesting again. Without application of proper judicial mind, enhanced the income of the claimant from rupees 6,000 to rupees 9,000 while passing the impugned ex parte. This was ex parte judgment and order dated 10/10/2019. Okay. So whether the claimant produced the income certificate on the basis of which you are submitting that it was 60, the claim was 6,000. Where do we find 6,000 claim?
Lordship, I do not have the reports, but
In a claim petition. Monthly income of the injured is 9,000 per month only in the petition. In the application under 166. Para 3, page 3, para 6, in monthly income of the injured. They stated that rupees 9,000 per month. 6,000 not mentioned. Do you have the copy of the claim petition?
No, Your Lordship.
So it is there. You would like to see? It is there because you need to confirm. Just let him see. It is mentioned 9,000. And for information, have you produced an income certificate also?
Income certificate not required, Lordship.
Is only.
Yeah, I
on some
satisfy
claim.
your Lordship, yes. Regarding this, I will satisfy your Lordship.
Was he working in some department? No.
He was just serving as a handyman in one.
Any certificate issued by the department?
No, Lordship. No, Lordship.
If he were working.
Because after accident, the owner of the vehicle is very much
Okay,
annoyed.
in private. No,
Yes,
no, not in
private.
private. Even in a private also, that the owner of the vehicle.
Lordship,
can-
at the time, at my time of submission,
So I think there is in
satisfy
the
your
claim, they have made specifically, you see, monthly income of the injured, 9,000.
Lordship.
Yes.
In that case, Lordship, I'll be allowed to drop this ground. I'm not pressing on this ground.
So,
There's been a mistake.
okay, this ground goes.
Lordship, I'm not
Okay,
pressing on
leave
this
that
ground.
then, huh? Okay, yes. Right, do you have the stapler? Is this stapler, anything, this page has come out? No? Somewhere, this corner. So, okay. Yes, and then what is the next ground then?
Lordship.
E is,
What are the limit member, motor accident claim tribal Mungchung Nagaland has failed to take into consideration that the claimant has miserably failed to prove fault of the driver of the insured vehicle by adducing evidence in causing the accident and thus fastening the liability upon the insured vehicle is highly arbitrary and liable to be questioned and set aside.
has failed to take into consideration that the claimant has miserably failed to prove fault of the driver of the insurer.
Your claimant has failed to prove that the driver of the insurance insured vehicle by the agency.
No, my earlier question, whether the case was registered,
Lordship.
case was registered, I think,
No, there is only GD.
or the GD. Okay,
Yes,
GD.
Lordship. But there is no ground in the appeal and there is no objection in the court below also.
Hmm.
Yes.
Okay, so. So this in the evidence, you have to see the evidence. Evidence, what, anyone stated that there is no, evidence? Let us see the evidence of the. Evidence, how many, witnesses you have examined?
There is 2 witnesses, Lordship.
Only 2?
Yes, Lordship.
Okay, so in the. Just a minute. Because this is general. Your allegation is general, so we need to see the. You mean to say that in both, the evidence of both the witnesses, PW 1 and 2, there is no evidence? According to you?
According Lordship, that the claimant has miserably failed to prove fault of the driver.
Fault against the driver.
That is,
So, could you?
using evidence of the IO
Hmm.
or the accident or the author of the FIR.
Were you able to bring out in your cross examination that there was no evidence? Because in the claim petition, they must have stated To save the cattle. We said that to save the cattle, the offending vehicle dragged the vehicle to the extreme roadside due to the high speed and rash and negligent driving. The driver failed to control the vehicle. And then could you bring in your cross-examination? So he denied your suggestion that it was not due to the rash and negligence. He denied.
No, sir.
Anyway, but then so in a cross-examination, you ask, of course, but then the witnesses denied
No, sir.
the suggestion.
So my
Okay.
next ground is a
Just a minute. huh?
H. Yes.
So this ground that the Lanet
That is E.
MACT Mokokchung Nagaland has failed to take into the consideration that the claimant has measurably failed to prove fault of the driver of the insured vehicle by adducing evidence in causing the accident and thus fastening the liability upon the insurer of the vehicle is highly arbitrary and liable to be quashed and set aside. Okay, next.
Next is a H, Lordship.
H.
Lordship.
Okay, what is that?
Ordered the Leonard Tribunal has erred in law by awarding on the hat of future medical expense, which is not in conformity with law, as no medical documents has been submitted before a tribunal regarding the need.
No,
Regarding the
medical
need for
document
further,
indicates,
it's for further treatment, Lordship, further treatment. As such, it seems liable to be squashed and set aside. The
Oh.
Leonard Tribunal below has awarded the sum of rupees 50,000 for future medical expenditure.
How much?
50,000.
Hmm?
50,000
50.
for future medical expenses.
Just a minute. Huh? Pain and suffering, inconvenience, future medical expenses, 50,000.
Lordship,
So you have objection to this?
Lordship,
Just a minute. Huh?
because there is no document to show that the claimant required
this is-
further medical
Just a
treatment.
minute. This is ground E.
H,
Oh, sorry, H.
H, Lordship.
Okay. That the Leonard Tribunal has erred in law by awarding and on the head of inverted comma future medical expenses comma inverted comma close, which is not in conformity with law, as no medical documents had been submitted before the tribunal regarding the need for further treatment, comma, as such, further treatment, okay. And under the said head, just a minute, medical document. Future expense, future awarding the head of future expenses for rupees 50,000. No,
Lordship,
okay, in that 50,000, which is not in conformity. Okay,
my last
yes,
ground is regarding the percentage.
okay,
Lordship, the percentage set by the Sarla Verma's case, it's 6% per annum, Lordship. The
so
interest,
percentage in under which ground? Ground number
J,
J.
last ground at page number 7,
Okay, so this is, the tribunal has awarded 9%.
9%.
So according to you, how much it should be?
Lordship, as per the ruling of the apex court
Hmm.
and lowly down by
Sarla Verma,
Hmm.
it should be 6%, Lord.
Okay, that the learned tribunal has awarded an interest at the rate of 9% per annum. And as such, the same is in violation of the law laid down in Sarala Verma's case reported in 2009-6 SCC 121. And the Code of Civil Procedure 1908, in as much as the MB Act 1988 under section 171 has not prescribed any specified rate of interest. Stop. And in the as per Sarala Verma, it should be 6%.
6%.
Okay, yes, sir. Sarla Verma's case reported in 2009-6 SCC 121, whereby it has been prescribed. And sorry, the interest for the interest has been prescribed is 6% per annum. Comma, and Code of Civil Procedure. Okay.
That's all, my Lord.
That's all. Okay, so yours is a limited prayer with regards to this 50,000 and then this interest. Okay. Okay, yes.
May it please your lordship, I
Yes.
have prepared a gist.
Yes, please.
So lordship, here in this case, out of total awarded amount 12,56,000, as directed by this honorable court, 50% of the awarded amount 6,28,000 has already deposited and allowed to withdraw by the claimant even.
Okay,
Lordship.
also withdrawn.
Yes, it is already withdrawn 50% as directed by this honorable court.
Okay.
Lordship, the fact of the case is that the injured respondent claimant by profession was a handyman working in the offending vehicle number AS01GC 9161. And in the course of employment on 19/8/17 at about 7:30 AM, while the claimant was traveling from Dhekiajuli to Tezpur and on the way at Bahabaguri, due to rash and negligent driving of the driver of the offending vehicle, the vehicle fell down into deep trance. Resultantly, the claimant sustained grievous injuries of polyturuma with public remi, fracture with lung contusion on SPSC, fracture of right jogmatic arch. Immediately after the accident, the injured was admitted in the GNRC. Thereafter, at Assam Medical College Hospital, Gauhati, EMM Hospital and Research Center at Tezpur, and at Konoklata Civil Hospital, Tezpur, for lordship. The respondent claimant was taking treatment from 19/8/17 to 2/10/17, lordship. This is the period of treatment. Very interesting, lordship. At different hospital and incurred huge amount of expenditures for his medical treatment. Under order of the Motor Accident Claims Tribunal Muguksung, the injury of the respondent claimant was re-examined by constituting a medical board, who after a thorough examination categorized the injury of the claimant as 60% permanent disability, that is Exhibit P13, lordship. The respondent claimant examined himself as PW1 and one attendant of the ambulance as PW2. No any defense witness was examined by the appellant. The learned member, being satisfied with the material evidence, documentary as well as oral evidence available before him, awarded total compensation of rupees 12,56,000 in favor of the respondent claimant, which is now under appeal, lordship.
Yes.
Lordship, the ground number 1, the ground number B and E, both are appeared to be similar in regards to the rash and negligent driving of the vehicle.
Yes.
Ground number B and E may be heard together, Lordship. Lordship, interestingly,
He is now not insisting, I think.
B and E,
It's
Lordship.
F. It's
B-
F.
No, Lordship, B and E are grounds similar. B is the learned member has prima facie committed error
Okay.
and illegally in passing the final award without taking into consideration of the basic requirement under Vehicle Act, Motor Vehicle Act prescribed under section 166.
Yes.
And now ground number E is, Lordship, for that learned member without application of proper judicial mind enhance the income of the sorry, Lordship, E. For the learned member, Motor Accident Claims Tribunal, Mukokthang, Nagaland has failed to take into consideration that the claimant has miserably failed to prove fault of the driver of the insured vehicle by using evasion in
Yes.
causing the
Okay.
accident.
Okay.
So both grounds are similar,
Yes.
maybe hard together. Lordship.
Yes.
Lordship, under Motor Vehicle Act, section 166, though my learned friend has stated that if a petition filed under section 166 of the Motor Vehicle Act, rash and negligence to be proved by the claimant.
Rash and negligence is.
To be proved by the claimant.
Okay.
According to the learned appellant, since the petition filed under section 166, the rash and negligence to be proved by the claimant. But Lordship, under section, in the provision of section 166, nowhere it is stated that the claimant ought to have proved the rash and negligent driving. That is not in the section 166 of the Motor Vehicle Act, Lordship. In the section 166 of the Motor Vehicle Act, it is very clear. Lordship, section 166.
Yes.
Application for compensation. An application for compensation arising out of an accident of the nature prescribed in subsection 1 of section 156 may be made.
165.
165 may be made. A, by the person who has sustained the injury, or B, by the owner of the property, or C, where death has resulted from the accident by all or any of legal representative of the disease, or D, by any agent duly authorized by the person injured, or all or any of the legal representative of the disease, as the case may be, provided that where all the legal representative of the disease have not joined in any such application for compensation, such application shall be made on behalf of or for the benefit of the all legal representative of the disease, and the legal representative who have not so joined shall be employed as a respondents to the application. Subsection 2, Lordship. Every application under subsection 1 shall be made at the option of the claimant, either of the claims tribunal having jurisdiction over the area in which the accident occurred, or to the claims tribunal within the local limits of whose jurisdiction the claimant reside or carried on business, or within the local limits of whose jurisdiction the defendant reside, and shall be in such form and contain such particulars as may be prescribed. Provided that there were no claim for compensation under section 140 is made, in such application, the application shall contain a separate statement to that effect immediately before the signature of the applicant. Subsection 4. The claim tribunal shall treat any report of the accident forwarded to it under subsection 6 of section 158 as an application for compensation under this act. So, Lordship, in section 166, there is nowhere stated that the claimant have to prove the rash and negligent driving for claiming compensation. It is not there, Lordship. Whatever it may be, but there are some discussion and reference of the Honorable Supreme Court. Earlier, it is like that. Earlier, petition to be filed under two provisions. One provision is under section 166, and the another provision is for section 140. So 140 is the called no fault liability. That is, that time it was only 50,000 for death and 25,000 in case of injury. That part is over now after amendment. So now, even that part also,
After amendment, now,
after amendment also, same procedure is prevailing. That there is no reference at all in the section 166 of the Motor Vehicle Act. The claimant has to prove rash and negligent driving. It is not there, Lordship. Lordship, my submission in regards to the ground B and E, their allegation is that no fault has been established under the against the driver as required by section 166 of the MV Act. My submission, Lordship, in examination of the respondent claimant as PW1, in his examination in chief stated, maybe your Lordship will find it from line 6 of the deposition in affidavit. On the day of accident, under course of employment, I was traveling from Dhekiajuli to Tezpur with the vehicle number AS01GC9161 on the way at Baghguri to save a cattle. The offending vehicle dragged the vehicle to the extreme roadside due to high speed and rash and negligent driving. The driver failed to control the vehicle, resultantly fell down into the deep trench and caused grievous injury of polyturuma with public rami fracture with lung contusion on SPC, fracture of right zygmatic arch. To reply the cross-examination, the claimant stated that I denied a suggestion that accident dated 19/8/17 was not result of the rash and negligent driving of the offending vehicle number so and so. In examination of the eyewitness, Lordship, it's an important witness, Lordship. In examination of the eyewitness, as PW2 stated that I am an employee of GNRC and working in the ambulance in the offending vehicle number so and so. On 19/8/17, as an ambulance attendant, I was traveling from Dhekiajuli to Tezpur and on the way at Bihaguri, due to rash and negligent driving of the driver of the vehicle involved in an accident and fell down into the deep trench. At the time of accident, myself and the driver somehow escaped with minor injury. However, Shri Pallabjyoti sustained grievous injuries. After the accident, we were admitted in the GNRC and taking treatment. The accident dated 18/8/17 was only the result of rash and negligent driving of the driver. To reply the cross-examination, the PW2 categorically stated that it is fact that the driver was in a reckless driving while driving, trying to save a cattle on the way. He dragged the vehicle to the extreme side of the road and resultantly fell down into the deep trench below the road. Further, from the available evidence before the learned tribunal, finding of fact about the rash and negligent driving of the driver of the offending vehicle is well established. No evidence to the contrary could able to produce by the appellant, hence no error has been committed by the learned tribunal. The allegation is ground number B and E cannot stand. Lordship.
yes,
The respondent claimant respectfully submit that MSC claim is a summary civil proceeding wherein claimant is not required to be proved the case as if like other civil and criminal cases. For satisfaction of this honorable court, the respondent claimant relied upon the following decision of our apex court. Same cases are already referred in the foregoing hearing, Lordship. May I read it again, Lordship? Yes, Lordship. Lordship, the next ground is the allegation is monthly income enhanced from 6,000 to 9,000. It is incorrect, Lordship. Because in the claim petition itself, it is written 9,000, same also considered by the member as 9,000. And pardon, it is dropped, Lordship. Yes, Lordship. I have no more discussion on this issue. Lordship, in ground number F, G, and H, all are appeared to be similar, Lordship.
yes,
Ground number F, G, and H.
is,
In my gist is number 8, Lordship.
yes,
The allegation is that no disability certificate file, no amount shall award for user treatment. My submission before your Lordship, the allegation is incorrect and wrong. According to the appellant, no disability certificate file at all. Under order of the tribunal, the respondent claimant was re-examined by a medical board who, after thorough examination, ascertained the disability of the claimant at 60% permanent in nature. The said certificate issued by the medical board is marked and exhibit as E13. When a person is suffered from 60% disability, awarding of future medical expenditures cannot be unreasonable, as the respondent claimant need future medical treatment for rest of his life. In the Ketna cases, Honorable Supreme Court even allowed future medical expenditures considering the disability of the claimant. The claimant is a 60% disability. By profession, he was a handyman. He need future treatment, day-to-day treatment for rest of his life. As such, awarding of future medical expenditures, it cannot be unjust and unreliable, Lordship. The next ground, Lordship, my learned counsel submit that in ground number J and 9. Allegation is that 9% interest shall liable to be dismissed. That is not correct, Lordship. Awarding of 9% interest per annum against the awarded amount on no error has been committed by the tribunal under the provision of law. Section 170 of the Motor Vehicle Act provides that where any claim tribunal allow a claim for compensation made under this such tribunal may direct that in addition to the amount of compensation, simple interest shall also be paid at such rate and such date not earlier than the date making the claim as it may specify in his behalf. Under this provision, awarding of interest is appeared proper. The respondent claimant relied upon the decision of the apex court. Lordship, there is a larger bench decision. ICICI Lombard General Insurance Company Limited, Ajay Kumar Mahantri, and another 2018 3 SCC 686 para 13. This is a three-judge bench, Lordship. Wherein Honorable Court held that 9% interest to be paid. The another three-bench decision of the Honorable Supreme Court in S. Thangaraj versus National Insurance Company Limited, 2018 3 SCC.
Sarala Verma's was decided on 2009.
Yes, Lordship.
So whether this has been overruled or what? Sarala Verma 6%.
That was earlier, Lordship.
Whether in any of the decision which are cited by
Sarala
you,
case reported on 2009 6 SCC 121.
whether any of the decisions cited by you,
Yes, Lordship.
whether this Sarala Verma's was referred?
No, not referred, but these are the larger bench decision, Lordship.
Yeah. Okay.
Where
Sarala
larger
Verma
bench,
is the decision of
larger bench, Lordship.
Sarala
Verma case is on the double bench decision, Lordship.
double bench.
Yes,
Okay.
Lordship.
Okay.
This is the first decision is ICICI Lombard General Insurance Ajay Kumar 2018 3 XCC 686 para 13. This is a three-judge bench.
Okay.
Held that claimant shall entitled to interest at the rate of 9% per annum from the date of filing of claim petition, Lordship.
Okay.
Again, in Thangaraj versus National Insurance Company Limited 2018 3 SCC 605. This is also three-judge bench.
Okay.
In para 9, Honorable Supreme Court held that claimant is entitled for 9% interest from the date of filing till payment. The another three-judge decision again.
You have to submit this decision, huh?
Yes, Lordship. The book list of books are already given, and in my written argument, in the gist of my argument, I have
Do you
already
have the copy of this decision?
Yeah, copy of the decision I have already filed, submit in the list of books.
Books?
Yes, list of books are there.
Okay. The Xerox copy, have you submitted?
I have not submitted any Xerox copy, but I have submitted the list of books.
Okay.
So there are hundreds of decisions wherein Honorable Supreme Court as well as our High Court has pleased to award 9% interest against the awarded amount from the day of filing of the claim petition till payment. So the ground set forth under this ground, the ground set forth by the appellant cannot be stand under test of judicial scrutiny and is liable to be dismissed with compensatory cost, Lordship. This is my submission.
Okay. So his submission will record first, huh? Ground taken by the respondent. In the beginning, the Land Council for the respondent submits that 50% of the awarded amount of rupees 6,28,000 has been deposited by the appellant white check number 2269998 dated 9/12/22 with the registry, and the same was allowed to withdraw by the respondent. The same was allowed and withdrawn by the respondent claimant. Stop. Number one, ground. The allegation that no fault has been established against the driver as required by section 166 of the MB Act. With regards to the allegation, MB Act, the Land Council for the respondent submits that in examination of the respondent claimant is EW1, in his examination in chief, has stated that that from stated that under inverted comma, I'll mark here, okay? Page 3, I'll mark. Within inverted comma, from on to arc. And in para, and in his cross-examination, the claimant stated that claimant in his cross-examination also the claimant denied. There's a suggestion made by the Land Council for the appellant that the accident dated 19/8/2017 was not the result of rash and negligent driving of the offending vehicle number is 01 GC 9161. Stop. Para. The Land Council for the respondent further submits that the eyewitness of the case was examined as PW2, and PW2 is a
Eyewitness of the accident.
lady or gents. What is the name? Name is there? What is the name of the PW2? The Land Council for the respondent submits that
Mr. Jyoti Prasad Gogoi.
Mr. Jyoti Prasad Gogoi was examined as PW. Submit that the eyewitness of the incident, Mr. Jyoti Prasad Gogoi, was examined as PW2. Stop. The PW2 stated that he was employee of GNRC and working in the ambulance in the offending vehicle number is 01 GC 9161. Stop. And on 19/8/2017, as an ambulance attendant, he was traveling from Dekiajuli to Tezpur, and on the way at Bihaguri, due to rash and negligent driving of the driver, the vehicle involved in an accident and fell down into the deep trench. Stop. At the time of accident, he and the driver somehow escaped with minor injuries, however, Sri Pallav Jyoti, within bracket, claimant, sustained grievous injuries. Stop. And after the accident, they all were admitted in the GNRC and were taking treatment. Stop. In his cross-examination, the PW2 categorically stated that and reiterated that the driver was in a reckless driving while trying to save a cattle on the way and he dragged the vehicle to the extreme side of the road, which resultantly fell down into the deep trench below the road. Stop. Now, as a result, the vehicle fell down into the deep trench below the road. Okay, stop. The land council for the respondent submits that it is clear from the above evidence, the learned member find out from the submits that from the available evidence before the learned members, finding of fact about the rash and negligent driving of the driver of the offending vehicle is well established, and no evidence to the contrary, no contrary evidence could be able to produce by the appellant, and hence no error has been committed by the learned tribunal staff. And under the circumstances, the ground taken by the appellant cannot stand. Stop. Okay. The land council for the respondent further submits that the MSCT claim, which is a summary civil proceeding, and the claimant is not required to prove the case, as in the case of the civil and the criminal cases. Stop. The learned counsel for the respondent also relied upon the following decision of the apex court. in the above point. One, I. So I have marked this, I'll mark. Page 4. 4,
5 and 6.
page 5. Entire, 5, this also. And 6. 6 up to here, okay. Next point. With regards to, next point, with regards to the allegation that no disability certificate was filed, sorry. Certificate was produced before the court. And as such, no amount shall be awarded for future treatment. The Land Council for the respondent submits that the said allegation is incorrect. In as much as in the instant case, under the order of the tribunal, the respondent claimant was re-examined by a medical board who, after thorough examination, have ascertained the disability of the claimant at 60% permanent in nature. Stop. After examination, the board had issued a certificate, and the said certificate issued by the medical board is marked as marked and exhibited as P13. Stop. And when a person is suffering from 60% disability, awarding of future medical disability, awarding of future medical expenditure cannot be unreasonable as the respondent, as claimed by the respondent. Okay, just a minute. As the respondent claimant need future medical treatment for the rest of his life. Stop. With regards to the claim of the appellant, sir, with regards to the claim of the appellant, alleging the awarding of 99% interest against the decision of in violation of the law laid down in Sarala Verma's case, reported in 2009 6 SEC 121 and 121, the Land Council for the respondent submits that by awarding interest at the rate of 9% per annum against the awarded amount, no error has been committed by the Land Tribunal under the provision of law. Stop. He further the Land Council further submits that Section 171 of the Motor Vehicle Act provides that this entire Okay, provides where the claim, this is page 9, right? Page 9, okay. And then these, another provision, this will appear proper, the respondent claim. Okay. Then also, you have also referred the Supreme Court order. This also you want to be included in your submission. Is Thangaraj decision in Thangaraj also? All the decision?
Yes, Lord. And
Okay.
Bhartiben Naya Baba.
Bharti, okay, this also page 10 also. Huh?
This two decision in part, page number 10.
Two decision in page number 10.
These two decision actually his husband's decision.
Okay, okay, true.
Yes.
Okay. Up to that was all, I think.
Yes, Lord.
Huh.
Sir.
And
This is my
then,
submission.
and then and the land council for the respondent submits that the judgment and award dated 10/10/19 passed by the land member, the land tribunal is reasonable, just and proper, and is not liable to be interfered by this court. And prays for, and hence pray for the dismissal of the appeal with cost. And in the beginning, and in the beginning. Will be the beginning. This is an appeal under section 173 of the Motor Vehicle Act 1988. Filed against impugned judgment and award dated 10/10/2019 passed by the learned member, Motor Accident Claim Tribunal, Mokokchung, Nagaland, in MSCT case number 44 of 2017. Start. Have you given the brief of the case?
Lordship, it is stated in my first page of the gist.
Okay. Okay. The brief fact of the case is that on 19/8/2017, under the course of employment, while the respondent claimant was traveling on the vehicle number AS01 GC stroke 9161 from Dikyajuli to Tezpur, and on the way at Bihaguri due to Bihaguri, due to rash and negligent driving of the driver of the offending vehicle, the vehicle fell down into the deep trench. As a result, the claimant sustained grievous injuries and become permanently disabled. Stop. Having been sustained injuries, the claimant has taken treatment at different places and incurred huge amount of expenditure. Stop. And after treatment, the claimant filed a claim petition before the MSCT against the appellant respondent. Stop. That. Right now, then respondent claiming a compensation of rupees 15,69,600. The para. The case was contested by the appellant respondent by filing written statement and denied the liability of the appellant. Stop. After hearing, on conclusion of the trial and after hearing the parties, the learned tribunal passed the judgment and order dated 10/10/2019, awarding an amount of rupees 12,56,000, directing the appellant to pay the said amount within 30 days from the date of the issue of the order, and in default, interest at the rate of 9% annum from the date of filing till the final payment, and hence. And being aggrieved and dissatisfied with the judgment and award dated 10/10/2019 passed by the learned member Motor Accident Claim Tribunal, Mokokchung, Nagaland, in MSC case number 44 of 2017, the appellant preferred this memorandum of appeal on the following ground that will come during. Okay. Okay. So in order, order. Both the land council for the appellant, Mr. And Mr.
B. N. Sharma.
B. N. Sharma appearing on behalf of the respondent number one.
Respondent number one.
Okay, stop. Hearing completed. Judgment reserved. Okay.
Vice Mayor.
This, I think, you have minutes. So this. This is. This also. This also from there. Solution and whether ruling. So that is to be xeroxed. And the entire book cannot go in my chamber. No? Tell the librarian to xerox it. No, it's not relevant. The list is there. Okay. This. Okay. That is fine. Okay.
Item number 29 to 31.
Yes, what is this case about? I think time is time. No?
Yes, Your Lordship. The case is about the allegation in the complaint petition. This case has been filed for causing of the criminal petition.
Okay.
Pending at the district courts. So the allegation in the complaint is that in the case, there is one particular witness whose name is Rajiv Chopra, and he has introduced all the petitioners with the complainants for supplying of basmati rice. And all the petitioners, they are from Dehradun, Uttarakhand, and the respondents, complainants, they are from Nagaland. So basically, that is the allegation in the complaint petition. And because of that, and there was a verbal agreement between the respondents as per the allegation in the petition. And because of that verbal agreement for supplying basmati rice all the way from Dehradun to Nagaland, and that is how verbally they have agreed. And on different occasions, respondents, they have sent money in the petitioner's accounts. That is the basically allegation in the complaint petition. So, Your Honor, before, as I said, about the facts of the case as per the allegation. But here,
So for hearing, I think we have, you see, time is off. There is a paucity of time, what to do. So hearing can't do now today.
it is as per the honorable courts.
So when do you want?
Your Lordship, matter may be fixed after 3 weeks, Your Lordship.
Okay. You are?
P. Suren.
Heard by counsel for the petitioner, Mr. P. Suryan. I'm also heard.
Ali
Counsel
Bozkul.
for the respondent, Mr.
Ali Bozkul.
Okay.
For all the sole respondents.
All the respondents.
Yes, there are sole respondents in all the three.
Representing all the
criminal petitions.
respondents, stop. However, due to paucity of time, the hearing could not be taking place, stop. Accordingly, as prayed for by both the land council for the parties, list this matter after 3 weeks. Okay.
Much obliged.